ಆಲ್ರೆಡಿ ಇದ್ರ ಮೇಲೆ ಮೆಮೊ ಕೊಡ್ತೀನಿ 124 ಎಷ್ಟು
124 38 134 29
ಇದು 39
ಆಮೇಲೆ 161 40
ಹಲೋ
ಹಲೋ
ಏ
ಹ್ಮ್
No audio.
If it is local settlement, usually they will there is a format and we will sign that and they will draw the award. But if it is a court settlement, we have to prepare a separate joint memo. My lord.
Which is convenient to you?
Convenient is, my lord, in all cases, my lord, local joint memo.
And then go before the Lok Adalat today.
You will not
It is submitted that they'll file the joint memo today. Let's just, the matter is referred to the Lok Adalat.
Not referred to local.
Not, they will file a joint memo before the Lok Adalat.
Cell number 2, Guru Prasad Bia.
Matter, file may kindly send to local.
File will send to the Lok Adalat.
Cell number 2, Guru Prasad Bia.
This also 1 and 2.
King Aruna, Your Lordship.
Cell number 3.
Serial number 2, I am printing Aruna.
Who is appearing serial number 2?
I'm for
Cell
the
number
appellant.
2.
He's the insurance company.
2, we are ready, Your Lordship. For
That's
insurance
what,
company.
file a joint memo. After 2:30, the file will be sent to the Lok Adalat.
Last occasion was not there, some other part.
Okay, Your Lordship. The appellant may be directed to approach the Lok Adalat to prepare giant memo. We will come and sign.
Cell number 3, Marigowda. Cell number 3, Marigowda.
See that file. Matter is settled and insurance company has agreed to pay an amount of rupees. What has been granted and has come up with the joint memo. Who appears to the respondent?
MS Sriram.
MS Sriram. Then what is going to happen with all these matters? Nobody is coming up with the joint memo.
Actually, in fact, speaking, my lord, this nobody is aware about this, my lord, regarding non-filing of the joint. Usually, my lord, in the Lok Adalat, this matter is sent to Lok Adalat. We will sign there, my lord, the agreed amount. So that's why, my lord, may I make one submission? By Monday, we will sign the joint in all cases. If others are agreed.
Send all these files to the all these matters from till 8.
Because the parties, my lord, they have to put seal because it's a company.
Adalat and it is submitted with the councils that by Monday they'll be filing the joint memo.
Cell number
5.
Serial number? It's only till 8, I said. Even the next also. 9.
Consortium has left 2%, so there are 7%. Lordship has given consortium amount only for 5%. That is 40,000. Another 2% it will become 80,000. Dependency, all other calculations are correct.
Who appears to the respondents? Mr. Ravish Benny. Give that file. 10.
Serial number 5.
Cell number 5. 5.
Please, PB Raju. Consortium 5 into 4. It is 7 into 4. Huh?
7 into 4. 7 into 4.
Let's see.
Dependency on Lordship has taken for 5 members.
Switch on the mic.
Dependency on Lordship has taken for 1/5. This thing has been 1/5. It has been taken on only consortium. 80,000 has to be given. That is 40,000 each for 7 persons are there.
Another 80,000 will,
Yeah. Okay. Yes, your lordship. 80,000. Lordship, last time I ordered 5,80,000 rupees. For that, another 80,000 rupees should be added, your lordship.
5,90,000.
5,90,000.
This correction shall be carried out in the website also. Yes. Till 11.
CL list number 2. Parked matter CL number 1. Ravi Shankar. Rajshekar for petitioner. Parmeshwara for city.
Till the 5. Hmm?
List number 2, serial number 1, sir.
Appeal petitioners.
List number 2, serial number 1.
Petitioner has filed. Same is number.
Seeking transfer from where to where?
Petitioner has filed. Same is number 258/24. But first additional signature Mandya. Mandya to respondent has filed. MC number 6/24. The same. The 21st certificate copy of petition. Said case was posted for 5/7.
Present petition is for seeking transfer of MC number 6 of 2024 from the third edition of Principal Judge Family Court, Bangalore, to the first additional senior civil judge at Mandya, where the criminal miscellaneous number 258 of 2024 filed by the wife is pending. The facts of the case are: the marriage has taken place between the parties on 29/4/2021. In the light of the disputes between the parties, the respondent had filed MC number 6 of 2024 on the file of the third additional principal family judge at Bangalore on 2/1/2024. Wife had filed the criminal miscellaneous number 258 of 2024 on the file of the first additional senior judge, civil judge Manya on 20/11/2024. It is submitted that the distance between both the places is about more than 100 kilometers, and it's difficult for the wife to travel all the way from Mandya to Bangalore. On the last occasion, the counsel for the petitioner was present, and there was no representation on behalf of the respondent. Hence, the matter was directed, and having heard the counsel for the petitioner, matter was directed to be listed under the caption part heard today. Today also, there is no representation on behalf of the respondents. Next, considering the fact that already criminal miscellaneous is pending on the file of the family court at Mandya, and the distance between both the places is 100 kilometers. This court deems it appropriate to allow the petition. Yes, next.
Serial number 2, Ravi Shankar for appellant. M. Narayanappa.
Appearing for appellant, my lordship. My lordship, we are unable to produce a certified copy of deposit.
I said not required. Not required, and you have to argue. That's how the matter is adjourned to today. No further adjournments. Pass over. Either your senior colleague, whoever comes, or else will pass orders on the merits of it.
Lordship,
2012 MFA.
Kindly post it for judgment, my lordship. Senior counsel is out of station.
Huh?
Senior counsel is out.
Even if he's not well, we'll hear this matter. You can't ask adjournment like that. Yesterday it was listed. Your colleague said today, let him come, or if he's not coming, we'll pass orders.
Serial
Yes,
number
pass over.
Post it
3,
for judgment, my
and
lordship.
Huh?
Kindly post it for judgment, lordship, because that.
Why judgment? I'll pass the judgment tomorrow, today. Yes.
serial number 3, and Krishna Swami for appellant. Pundika Ishwara Bhatt for respondent.
You were not there yesterday.
See, no,
Senior is held up in other court, madam. Kindly pass on, madam.
Yesterday, no representation in
No,
the
no
morning.
representation.
No representation in the afternoon. Now again you ask for a pass out today.
No,
How
today,
many times the matter has to be listed?
today we will argue, madam. Kindly.
Pass out.
Cell number 4. Kalyanar for appellant. G. Lakshmi Rao for respondent.
You that. There is no representation on behalf of the appellant in MFA number 7099 of 2015 on the last occasion, and only the counsel appearing with the RTC was present. Today also there is no representation. List is matters for dismissal tomorrow. And today there is no representation in both 4 and 4.1. Yes.
Cell number 5. Cell number 5. Shripad V. Shastri for appellant.
My lord, I am representing appellant counsel.
Pradeep.
Not in station, kindly have it on Monday.
Monday. At request. Yes, next.
Cell number 6. Cell number 6. Vinod Kumar.
done in course of the day, madam.
Why there is no representation on the last occasion?
We have got the,
Who is R2?
my lords, we have got the NOC of
Huh?
this,
You the
NOC of
file.
this file, my lords.
R2 is United India Insurance Company.
I'll serve them, my lords.
Already there is wakalat. Where is the question of furnishing PF to this R2? Wakalat is filed. Where is he, the counsel?
He is not there, my lords.
Is not?
My senior has been outstations, my lords. Next week, my lords.
No representation on behalf of on the last occasion. There was no representation. The matter is listed today for dismissal. Today also. Again, again time is sought. List this matter after in the month of December. Delete from the caption dismissal.
Cell number 7. VC Sitaram Rao for appellant.
Yes.
Okay, for respondent number 1 in this matter.
Is he there online?
That's an.
Yes, he is. Please say.
Not, it's a may I please, Max?
Yes. Yes.
The alleged accident is dated 14/5/2015.
Insurance company is on what ground? On liability?
Liability, misrepresented claim.
Huh.
Not on 14/5/2015. The
Is this
claimant
matter
suffered
argued,
injuries.
is this matter argued earlier?
Please, my lord, it was argued before.
And you said that you will, because there are certain documents to be seen, you said you'll come to the court and argue.
Yes. Unfortunately, I am so down that I am unable to even travel.
Then we'll have it after vacation, delete from dismissal. This is matter after vacation.
That's right. There be any date fixed, my lord, because.
On 17th of June.
Please, my lord.
Obliged.
Cell number 8. Rangegowda NR.
Matter may be referred to Adalat, my lord. We'll settle before the Lok Adalat.
Yes. It is submitted that the matter may be referred to the local adalat. History is directed to place this matter before the local.
Cell,
Much of
cell number 9. Naveed Ahmed for appellant. Ananda KS.
Lords, on behalf of appellant, my lords, I have received the instructions that I am going to file NOC Wakalat, my lords. NOC Wakalat, my lord, from the appellant counsel, my lord. May kindly have it next week. I will argue the matter.
Last time also I think some this kind of a representation.
No, but I have not appeared, my lord. This is the first time I am appearing.
Last time nobody has represented.
What is the matter?
Enhancement, my lords.
We'll see.
Please, my lords.
Pass out.
Fine.
Can you pass out?
Ask him to increase the fan. Fan. Ask him to increase the fan.
Cell number 10. Cell number 10. Suguna R. Reddy for appellant.
Senior is on the way. Kindly may pass around. Senior is on the way, ma'am.
Non-compliance of office objections on IA number 1 of 25 to IA number 3 of 25.
In this case, my lord, first respondent was represented by one Pattabhiraman. He made a submission stating that first respondent is dead. So thereafter, I made my sincere efforts to find out the addresses of the LRs. But date of death, I am not able to give. That is my problem.
You have to find.
But liability is on
You
the
have to
insurance
get the-
company.
Liability is?
It's an insurance company.
Insurance
far as-
company has not preferred any appeal.
No, my lord.
Then in that case, you say that they are not necessary. Then
Yes.
all these will go.
Yes, I will file a memo. I am
A
ready
memo.
even on merits also.
File a memo.
Yes, my lord. Today itself I will
A
file.
memo is filed
Yes, my lord.
stating that the liability is fixed on the insurance company and the respondent number one is not a necessary party, and the notice to one may be respondent number may be one may be dispensed with at the risk of appellant. Accordingly, memo is taken on record and notice to R1 is dispensed with, and in view of the same, IA number 1, 2, 3 of 25, 25 or dismissed as not pressed.
Yes, much of
Yes, admit post for final hearing.
much of
Memo putting. Cell number 11. Shivaramu HC for appellant.
For appellant, Your Lordship. Press for time for 2 weeks. My senior is admitted to hospital for surgery.
Why there was no representation? Why so casually cases are taken by the councils? First of all, no representation. Again, in a dismissal caption, again asking for time. There should be some reason for that.
Next that I will argue.
Huh? What is that? Huh?
Senior is not keeping well, my.
Then you should be there when the matter is called. It is not as a matter of routine or practice, it is listed for dismissal. So why should I accommodate your request today?
One.
Non-compliance of office objections, MSA of 2024. Finally, a week's time is granted for complying with the office objections, or else the appeal shall stand dismissed
Last time itself we have.
without further reference to the court.
We have complied with in the
When did you
last-
comply?
On that day itself we have complied.
It's still coming under the same caption. Yes.
Cell number 12. Satya for petitioner.
Give that there is a memo. A memo is filed stating that the parties have settled the disputes and have obtained the mutual divers. As such, the petition may be dismissed as before. Accordingly, memo is taken on record. And the same is dismissed as before. Yes.
Mohan PK.
For petition, my lords. My lords, in the previous date of hearing, your lordship had directed me to survey copy on the respondent counsel before the trial court, my lords. None appeared before the trial court, my lord, from the respondent side. As such, I have sent to register post directly to the respondent, my lord, on 4/4 itself.
When you
And I
say
filed a
when,
memo, and I
when
filed
the
a memo
court
to that,
passes an order
my lords.
to issue hand summons, how can you send it by registered post?
No, my lord, because they were not available to receive a copy, I just sent a copy of the same to the respondent.
Why did you say so? First of all, you have to find that they have refused. A memo shall be filed before the
They did
court.
not refuse. Nobody appeared, my lord, before the trial court. It's not that they refused, my lord. No,
Nobody appearing, refusing. There are two different things.
No, my lord, nobody appeared from the petitioner side therein, my lord.
If that is not, then you don't you know the address, sir. You will see him only in the
I have
court.
sent, my lord. I have sent. I did not know because the
You
party
can't
is
send
not,
it. You have to serve the hand summons.
my lord, the party is
As
not
per
being
the order
represented.
passed by this court, the petitioner shall serve the hand summons on the respondent and file a memo to that effect
I have filed a
by
memo yesterday, my lords, in the registry.
10th of June. This is matter. If
Well,
it
the
stays there,
interim order may be extended, my lords.
and if the memo is not filed by 10th, the stay granted by this court stands vacated.
Grateful,
Interim
my
order granted earlier is extended. Yes.
Cell number 14, Raja R.
Another copy to the trial court advocate.
What is his name?
Mr. Chelvaraju, my lord.
Have you stated so
K. Chelvaraju.
in the memo? Put in the name of Mr. K. Raju, advocate. This is matter on Monday.
21.
It is submitted that as per the order passed by this court, he has served the notice on the council, Mr. So-and-so. These three is directed to print the name. Yes, ma'am.
Interim order may kindly be extended, my lord.
Interim order only granted is extended till the next date of hearing. Yes,
Cell
ma'am.
number 15,
For petitioner, last occasion your lordship has issued hand summons. I have served it and yesterday only I have filed acknowledgement. Acknowledgement I have filed.
What is the name of the advocate?
Advocate name is H.N. Himant Raj.
So where from the court has to read it?
I am sorry, my lord, it is
Write it in the memo.
please.
Yes.
It is appearing on the hand summons.
First write it, then
Please,
we'll call the matter. Yes.
Please.
cell number 16. Cell number 16, BC Tippeswamy for appellant.
In this case, Umesh has filed wakalat on behalf of the second respondent. My name may be deleted.
Who filed?
Umesh.
Where is your name?
Prior to that, my lord, my name
I
is.
think it is in 16.1. In 16.1, delete the name of Mr. Shivanagowda for R2. Then, where is the counsel for the petitioner?
Tippeswamy, BC.
Mr. Tippeswamy. Notice is not, R2 is who? R2 is insurance company.
Please.
Then R2 insurance company is already served. R2 for first time. Please find out why they are writing these kind of notes. When the notice is already notice is served on the second respondent, and second respondent has already filed the Mr. O. Mahesh has filed wakalat on behalf of the second respondent. Admit post for final hearing. In both the
Number
cases,
17.
same thing.
17. Ketan DT.
R1 is ex parte.
Who is R1?
Owner of the vehicle.
The memo is filed stating that
Kindly may refer to local.
stating that the owner of the vehicle such ex parte. Hence, may notice to the first respondent will dispense with same accordingly. Then the next parallel and counsel submits that the matter may be referred to the Lok Adalat. This is that to place the matter before the Lok Adalat. Yes.
Cell number 18, BC Shivanagowda.
The memo is filed seeking acceptance of paper publication in respect of respondent number 2 as per the order dated so and so. Accordingly, notice to R2 is held sufficient. IA number 1 of 16 is filed seeking condonation of delay of 38 days in filing the appeal. Considering the reasons stated, the delay is condoned. What is this appeal about?
regarding liability, my lord.
On what? Why you say that you're not liable?
No, my lord. Tractor trailer has been used for commercial, agricultural tractor trailer has been used for commercial purpose, and the income was taken.
Income was?
It's taken on the higher side.
Is it a
And
case of death or injury?
it's a case of death.
We'll see then.
It may be have done tomorrow, my lord.
Tomorrow.
Tomorrow. Serial number 19.
I'm appearing for the appellant.
Ashok,
Take the
can-
necessary steps to file. the
Steps to be
appellant,
taken in
application
respect
for
of
the paper
R7 since
publication.
4 times notice issued. What is it?
I'll take the necessary step to file the
It
application
is
for the
submitted
paper
that
publication.
they'll come up with an application for substituted service of notice in respect of R4 list this matter after vacation.
Serial number 20. 20.
Respondent number 1 and 2 in this case, ma'am. Lord, in this,
I number 1 of 17 is filed by whom?
that is filed by the petitioner for condonation of delay. There is 2 years delay in filing the appeal.
The R4,
R4 is the insurance company.
who
Whereas
represents? Who represents?
liability is fixed on the appellant owner, my lord, in this case, my lord. Earlier, the MSCD tribunal has dismissed the claim petition.
Who are the claimants?
I am for the claimant.
No representation, lists this matter for dismissal. Counsel for the respondent is present.
Date may be fixed, ma'am.
Tomorrow.
Please.
Serial number 21. Serial number 21.
Appearing for appellant. Already previously.
MR Hirematta.
Already previously. We have paid a
Who is R2? Look at it. Who is R2? Give the file. Reliance? Mr. P. Pradeep is directed to take notice on behalf of the second respondent insurance company and the land counsel for the party appellant shall serve the copy of the appeal memo on the counsel. Which year is this?
Serial number 17.
2017. Admit call for the TCR. No, there is IA number 1 of 17 is filed to condone the delay of 147 days for the reason stated. The delay is condoned. Admit post for fine hearing. TCR. Yes, next.
Serial number 22. Basavaraju MS. 22.
No representation for dismissal tomorrow. Yes.
Serial number 23.
A memo is filed seeking dispensation of notice to R2. According to the same as memo is taken on record and dismissed at the risk of appellant. Admit post for final hearing. TCR. Next.
Serial number 24.
I'm appearing for the appellant, my lords. During the course of the day,
Gowda.
during the course of the day, I'll pay the pre-process.
Who is R2?
Right.
Insurance company, my lords.
Which insurance company? Mr. P.P. Raj is directed to take notice on behalf of the insurance company. And the same counsel shall serve the copy of the appeal memo on the counsel. Yes, admit. TC, call for the TCR. Next.
Grateful.
Interlocutory application, serial number 25.
Please, my lords, I appear on behalf of the applicant. My lords, we argued this on the last occasion. I'll do a quick, my lords,
My lords,
in
I'm
a.
filing an application for amendment. I've also engaged senior counsel. He's on his legs. I seek a passover. I'm filing an application to amend the petition.
Now, after this matter has been argued by me, my friend had started the arguments. But I had indicated on the last occasion, in fact, the court had observed the manner in which, my lords, defendants are attempting, or rather the petitioners are attempting to, my lords, delay this. Please see, my lords, the order sheet. 5 occasions, my lords, adjournment sought. On the eve of the matter, an application is tendered to say, now, please, I want to amend the petition.
So you will amend the petition whenever you feel like doing it. You take an order on some pleadings which are not permissible and which you cannot maintain a petition. Now you file an amendment petition, and the court had heard him at length, wasted a lot of time.
I bow down. I'm seeking a passover. I've engaged senior counsel. He's on his legs.
But to argue this matter, that's fine, my lord. This new application in.
We'll see, and then if the court comes to the conclusion that it's an abuse of process, we'll impose exemplary costs. Let them take a chance. Pass over. Yes, next.
Your lordship will be taking it at the end of the board, my lords. Pass over. I'm sorry, my lords.
I don't know what's pass over for them. Pass over is it?
After the list is over, at my lord's convenience.
Yes, ask the senior counsel to come.
I'm grateful.
Yes.
Cell number 26. Gaurav Subramanya.
Petitioner's minutes. The petitioner is seeking a transfer of the petition from Chikmagalur to Mysore, my lord.
What is this dispensation?
Dispensation is that, my lords,
Why you can't file?
it is only on only one occasion the order sheet has been changed. Only the last order sheet, my lords. Only one date has been changed.
No, probably that which you don't want to file that.
No, nothing like that. Not suppressing anything.
MC of which year?
My lords, this is OS, my lords. The respondent has filed for the
Suit of
conjugal
which year?
suit of 24, my lords, November. Petition is a wife.
File.
My lords,
When will you file?
my lords, I have to
For
seek.
the present, we will dispense.
Yes, my lords, I'll file.
I number 1025 is specifically dispensation of production of the audit sheet from 21/2/2025 to 6/4/2025. In OS number 258 of 2024, when council submits that, within 3 weeks, it'll produce the same. For the time being, the production of the same is dispensed with. Yes.
Respondent is the wife, my lord. The petition is the wife, my lords, wherein the respondent has filed for the suit of conjugal rights, my lords. Seeking remedy of conjugal rights, wherein the petitioner is resident at Mysore, my lords. But the present petition has been filed in Chikmagalur, which is more than 250 kilometers, along with a 3 years child is there, my lords.
She's staying at Chikmagalur.
Mysore,
And he filed at
Chikmagalur, my
Tarikere.
Chikmagalur.
Land council, the present petition is filed seeking a transfer of OS number 8 of 2024, filed with the respondents on the file of the additional civil judge and JMFC court at Tarikere, seeking restitution to the civil judge and JMFC to the family court at Mysore. It is submitted that the distance between both the places is about 250 kilometers, and it's difficult for the wife to travel, and she has to take care of
3 years old child, my lord.
3 years old child. Considering the same, they shall be stay of all further proceedings in so and so. The hand summons to the counsel for the respondent and shall file a memo by 22nd of July. If the same is filed, this is matter on 23rd, or else the stay granted with the court stands vacated. Next.
Number 27.
Watch out.
Muhammad Saluddin.
Lords, the petitioner herein is the wife, your lords. The petitioner herein is the wife. Respondent is the husband, your lords. The husband has initiated a divorce proceeding in principal court Udupi, your lords.
Udupi.
Yes, your lords. So the wife and the minor child that is aged about 4 years are residing in Bangalore, your lords. So that is why we have filed this petition seeking for the transfer.
Distance?
It's around 320 kilometers, your lords.
320
kilometers. 10 hours drive, your lords.
Which year is the MC?
This year, sir. Latest, your lords. 2025. Yes, your lords.
The present petition is facing transfer of the MC filed by husband from Udupi to Bangalore.
Yes, your lords.
Udupi to Bangalore. It is submitted that she has to take care of the child who is aged about
4 years.
4 years, and the distance between both the places is about 320 kilometers.
Yes, your lords.
Considering the said submission, they shall be stay of all further proceedings in so and so. Same, like in the last case, take out hand summons.
Please, your lords.
Same dates.
Please, your lords.
Yes.
Your lords, the case is on 2nd of May, your lords. Next date of hearing is on 2nd of May.
So stay is granted. It will come on July.
Please, your lords.
Yes.
Cell number 28. Ashok N. Patil for appellant. T. Parmeshwarappa.
Password.
Cell number 29.
Or else this IA number 1 of 25
For the
is filed seeking early hearing by the respondent. It's an MPP of 2019. This is matter in the month of August. Yes.
Number 29. Cell number 29. Sripad V. Shastri.
No representation after vacation.
Cell number 30. Spurti Egdayan.
For petitioner, my lord. Madam, petitioner is the wife, my lord. She is seeking transfer from Bengaluru to Chelikere, my lord.
Bangalore to
Chelikere.
Cherikere.
Chelikere. The distance is between Bengaluru to Chelikere, my lord, 200 kilometer. Petitioner has filed criminal miss before the Chelikere Principal Court, my lord.
Is there stay in this?
My lord, yes, my lord.
MC of which year?
2023, my lord.
Stay was granted in 24.
Now, the criminal miss is still pending, my lord, which is filed by the petitioner for maintenance, my lord. He has to appear there, my lord. Now, petitioner is staying with her old parents, my lord.
Where is the counsel for the respondent?
My lord, before the advocate who appears before the trial court, my lord,
Not notice.
we have served, my lord.
The present application is filed seeking transfer of MC number 4622 of 2023, pending on the file of the 4th edition Principal Judge Family Court, Bangalore to Principal Civil Judge and AMFC at Chelikere. The facts of the case are that the marriage has taken place on 29 May 2021 at Chelikere as per the Hindu rights and customs. It's a case of the wife that on 12/3/2022 she was thrown out of the matrimonial home, that is at Tumkur. Thereafter, on 27/2023, husband has filed MC number 4622/2023, seeking dissolution of marriage before the 4th Additional Principal Judge, Family Court, Bangalore. On 9/2/2024, wife had filed criminal misdemeanors 155 of 2024 at Principal Civil Judge and JMFC at Chelikere. It is submitted that the distance between both the places is about 200 kilometers. And any children?
No, my lord.
And and she's staying along with the old age parents. It's difficult for her to travel from Chelikere to Bangalore. The next paragraph. This court had directed the land counsel for the respondent, the land counsel the petitioner, to take out hand summons on the counsel for the respondent. Accordingly, he has taken out notice and filed a memo to that effect. No wakalat is filed on behalf of the respondent. Next paragraph. Considering the fact that the distance between both the places is about 200 kilometers, and the already wife had instituted criminal misdemeanors number 155 of 2024 on the Principal Civil Judge and JMFC at Chelikere, this court deems it appropriate to allow this. Yes, next.
Cell number 31. Gangaramovi.
I will file my objection. You will also kindly call it after some time. I send it for after vacation. Yes.
This is part after vacation at the request of land counsel petitioner. Next.
Cell number 32. B. Sharath Gopkumar.
Lordship, the
Chandrakant sir.
counsel for the respondent seeking pass order.
My lord,
Chandranath Ariga.
kindly recollect, my lord. Wife is staying in Bangalore, and twice they had taken time. A small child of 4 years, and he visits the child every Sunday.
Remember, we'll pass orders in the afternoon.
Yes, my lord.
Pass orders.
Yes, my lord.
Yes. Ask him end of the list.
Yes.
Yes, next.
Cell number 33. Parmeshwarappa City.
For the respondent, I'm filing an application, Wakalat.
My lordship, petitioner is the wife,
When did you receive the notice?
22nd March.
I have received on 26/3/2020.
26/3.
Yeah.
What is your objection for transfer?
No, I'm filing an Wakalat now, my lord. Hands up.
Received notice long back. Why are you filing
But
wakalat
now we are filing an Wakalat.
The intermodal is there.
Yes, my lord.
The land counsel appearing for the respondents are file it in the registry, not
Yeah.
Land counsel appearing for the respondent, land counsel so and so submits such as instructions to file wakalat, and she'll come up with objections and seeks time. This is matter after vacation. Intermodal earlier granted is extended till the next date of hearing. Yes, next.
Cell number 34. Shivananda DPS.
It is as per the order passed by the court. The notice, the petitioner taken out the hand summons on the counsel for the respondent. One Mr. D.M. Baswaraj. The registry is directed to print the name of the advocate Mr. D.M. Basura is in the cause list. Is this matter on Tuesday?
Interim order.
Interim order earlier granted you this time.
Not granted. Some hand summons was earlier
It
direct.
is about the husband's petition.
No, the transfer petition.
So we'll pass the final orders on Tuesday.
Tuesday.
Tuesday is, yes.
Cell number 35, Chandrasekhar P. Patil for petitioner.
Please, friend. This is a wife's petition seeking transfer from Bagalkot to Davangere Melad. In Davangere Melad, she has filed a CMIS.
Which year is the MC?
MC Melad is 145 of 24. And the child is aged about 12 years. The distance is 267 kilometers.
Number 145 2024. Pending on the principal judge family court, Bagalkot to the family court at Davangere. What is the distance?
267 kilometers.
We submitted the distance is 266 kilometers. And the wife has to take care of the child who is aged about
12 years.
12 years. Considering the same, they shall be stay of all further proceedings and so and so. The hand summons
A notice has been served, man.
is already served.
Please.
The
Notice is
no
served.
notice is served on the respondent. No wakalat is filed on behalf of the respondent. Considering the fact that the distance between the places is so and so, and the wife is residing at the place and taking care of the child, this court deems it appropriate to allow the petition. Yes.
Much.
Cell number 36,
Appearing for the petitioner, my lords, petitioner wife. The petitioner wife has filed a criminal miss 115 of 24 in Chikmagalur, whereas the husband has filed an MC case in Bangalore for restriction of conjugal rights.
What's the case?
The
Of which year?
24.
You're seeking transfer from?
No, my lords, I'm saying stay of the proceedings, transfer of the MC from Bangalore to Chikmagalur,
Distance?
250 kilometers.
It is submitted that the present petition is filed seeking transfer of MC number 758 of 2024, filed with the respondent seeking dissolution of marriage on the file of the fourth edition.
Restitution of marriage.
Restitution of conjugal rights before the fourth edition Principal Judge Family Court, Bangalore, to the Court of Principal Judge Family Court at Chikmagalur. We submitted the distance is about 150 kilometers and it's difficult for the wife to travel. Considering the same, they shall be stay of all further proceedings. Hand summons by 15th of July. This is matter on 16th, or else the stay granted by this court stands with you.
cell number 37, Pallava R. for petitioner. Sushant CV for respondent.
Presentation for the respondent. Counsel for the petition is present. Is this matter as part for tomorrow?
Cell number 38. Cell number 38.
Petitioner wife not seeking transfer of not the husband petition from not the KGF.
Number, when is the matter coming up?
That is not the husband's petition, that is MC number 83 of 2023, not now posted at 9/6/2025 for evidence. And not the wife's petition is posted on 24/4/2025 for evidence.
No. We are concerned with the husband's petition.
Yes, ma'am.
That is 9/6/2025.
Yes, ma'am. 9/20.
Please take notice.
Not this taking into consideration of the fact that not her father is suffering from not the gang.
That is from 2023. That fact is
Correct,
there.
not
Please
right.
understand. Court is following the procedure. Counsel for the petition is permitted to take out notice on the counsel appearing before the trial court and shall file a memo to that effect by 2nd of June. By 3rd of June, if the memo is filed, is this matter on 4th June?
Cell number 39. Kiran, Dhanushri.
I pray for some time in this case, my lord. There's some inconvenience. Senior is not available, my lord.
Huh?
Senior is not available, my lord. His out.
What is this matter about?
My lords, the respondent herein, my lords, has filed a suit for recovery of damages and for defamation, challenging which, my lords, the wife has come up with this petition, my lords, seeking to transfer. My lords may kindly see the suit is pending since from past 3 years. That is, the suit is of the year 2022. Since then, my lord, they have subjected themselves.
Counsel for the respondent in part. This is matter as part for tomorrow. Yes, please.
Cell number 40.
Yes.
Petitioner seeking transfer from
Choice.
Dakshina Kannada, Mangalore to Modigere, Chikmagalur, Your Lordships. Distance between
Go to
Modigere, Chikmagalur. Distance is 150 kilometers, Your Lordships. Petitioner wife is seeking transfer.
kilometers.
Yes, Your Lordships.
Which year is MC?
MC is of 24, Your Lordships, filed by the respondent husband,
Yes. The petition is filed.
who already filed a restitution in Chikmagalur, Your Lordships. And he knew that she was staying there.
Filed seeking transfer of
Prayer is at page 13.
17 of 2024. Pending on the file of the first registered principal judge family court Dakshina Kannada, Mangalore to the senior civil judge JMSC Mudigere. It is submitted that the wife is staying at Mudigere and she has also filed MC for restitution.
Restitution, yes, Your Lordships.
MC number 9 of 2025 seeking restitution and the distance between both the places
150 kilometers.
150 kilometers. Considering the same, they shall be stayed same in the in the earlier case.
Yes, Your Lordships.
And someone's
Grateful.
41. Umesh DS for petitioner.
My lord, I appear for the appellant, my lord. It's on
Respondent.
liability. Tuesday or Wednesday, my lord, may kindly take up on. Admit, it may be admitted and posted for hearing, or it may be whatever my lord feels. There is some personal function at home, my lord. Tuesday or Wednesday matter may kindly take.
Tuesday. This is matters
No
factored on Tuesday.
Cell
At the
number
request of Land Council, heard the Land Council for the respondent in part. This is matter as part heard on Tuesday.
Cell number 42. O Mahesh for appellant. Neeta Raj Ballal. Raj Ballal.
No representation on behalf of the insurance company. Land Council appearing for the respondent as present. List this matter after vacation.
Cell number 43. Chandrasekhar R for
I appear for appellant counsel, my lord. Claimant's appeal, my lord.
Who appears
Sri
to the
Shaila.
respondent?
Claimant appeal, my lord.
Where is Sri Shaila?
Sri Shaila is
I
there.
have filed the application, my lord, of production of the additional document, my lord.
Consider that where is he?
Please.
Will be considered along with the main.
Yes, Sri
appeal
Shaila,
itself.
sir.
Is there?
I appear for the respondent, my lord.
Are you ready?
My lord, kindly have it next week, my lord. I am not well today.
My lord, old matter, my lord, 2016, 2013 accident, my lord. Kindly have day after, tomorrow day
Tell
after.
him the reply, what should be the course of action now. He says he's not well. Let's
I am
matter
not
on
well.
Wednesday.
Yes,
This is
my
a
lord.
matter on Wednesday. We will take up.
Please. Much.
Cell
I
number
got
40.
MRI. I got the report today.
Sir, Wednesday.
Anytime, my lord. Next week, my lord.
Wednesday.
Next week.
Yes. Cell number 44. Nagabhushan IS.
Carry for the appellant, my lord. Owner's appeal, my lord. Only on the ground that I have not produced the specific class of is a tanker, my lord. For training
Sir,
the
what is the vehicle involved?
lorry, my lord. Petrol tanker, my lord.
Petrol tanker.
Please,
Then
my lord.
hazardous
We have
one.
a vehicle DL also, my lord, and also I produced this in appeal, my lord. I certificate of that hazardous goods transportation course training course certificate also I produced, my lord.
No. He should have a special license for that. Class of license.
Heavy vehicle goods and also I have training of hazardous goods transportation, my lord.
Yes, Ms. Yunagowda? No, for driving these kind of vehicles, there would be a special license.
No,
For the tanker, gas tanker. Yes.
Petrol tanker.
Heavy vehicle goods it is a DL so with training is there.
Training is, but a special
License will be
endorsement.
there. License will be there. Training is different.
DL also I produced, my lord.
Not simple heavy goods license for those kind of vehicles.
In order to drive a hazardous goods
Vehicle.
there should be an endorsement.
This petrol tanker is also covered under.
Hazardous.
So once that is not there, that's violation of terms and conditions. Once it is there, then the pay and recover.
Pay and
You are the
recovery.
owner of the vehicle.
I will verify, my lord, because as per my lord, my certificate and also.
But there is a license for that pass over.
Please, my lord, kindly admit and call for record also, my lord, because I produce extract R1.
No.
TCR, next week, my lord, kindly have it. I will verify and I make.
Not required in this case.
Owners of, I will verify and I'll make submission
This
next
is
week.
matter on Thursday.
Oblige, madam.
24th.
Yes.
Serial number 45, Harish Bhandari T.
Appear for respondent, my lord. In case of injury, my lord,
P. Rupesh.
The appeal for the appellant or the respondent?
respondent, my lord. Claimant, my lord.
The insurance company's appeal.
Insurance company,
On what ground?
Harish Bhandari.
and stating that, my lord, the award amount is, my lord, higher.
List this matter for dismissal, no representation for the insurance company.
Tomorrow.
Hmm.
Serial number 46, Sri Harsha AK.
Please, for appellant, my lord. Claimant appeal for enhancement, my lord.
Please issue an
At least finally one appeal we are hearing. I think for everybody, the vacation mood has already set in.
17/6/2016 is the date of accident.
17/6/2016.
6/2016. Stress injury on the right foot and nasal bone fracture.
How many are the injuries?
Only 2.
My lord,
Please come to the, straight away come to the table.
Arrow.
So one is a grievous injury.
my lord, there are two injuries, my lord. One is crush injury to the foot, my lord. Another one is a fracture of nasal bone, my lord. He got admitted to the hospital for 2 months. 2 months.
Injury will take 60,000.
20% limb disability was assessed by the
We'll
doctor.
go step by
Please,
step.
please.
So how many days he was in hospital?
2 months, my lord.
19/6 to 17/8.
And he underwent surgery also, my lord.
1 minute.
Sorry, my lord.
So for 60 days, we'll grant 60,000.
Please.
Then medical expenses as it is?
Please, my lord.
What they have? 1,61,420.
Then which year is the accident?
2016
accident, my lord, 10,000 is taken.
My lord,
Should
actually,
have been 9,500.
my lord, PW2 is the proprietor of the bookselling books, my lord.
You have not preferred any appeal.
No.
My lord,
Therefore, that has to be written.
appellant was working as a bookseller under PW2, my lord. PW2 he has
Document for
Already in
please.
hospital for 2 months.
Please.
So after discharge from the hospital, we'll take, in all the cases, what are we granting? Minimum 3 months we are granting.
3 months.
In that case, 2 + 3, 5 months are required. So loss of income during the later period.
Court has granted 30,000.
We'll
we
have
need to
50,000 now.
Please.
10 + 5, 10 into 5, 50,000. Then
my lord, regarding his income, my lord.
future earning.
Please.
My lord, regarding his income, my lord, PW2 he has given evidence, my lord. He used to pay 12 to 15,000.
As per the doctor's evidence, what is the disability?
20% to the
my
limb,
lord.
7% was taken to the whole body.
Correctly taken.
Regarding income, my lord.
How much was taken?
My lord,
How much was taken as income?
12,000 to 15,000, my lord.
Court has considered 10,000.
And 10,000, my lord. But he has examined proprietor, my lord. He has.
See the discussion why the court had taken only that amount.
My lord,
Which para?
para number
12. Read.
12, my lord.
Read.
Petitioner has examined the witness as PW2 who has issued the certificate as per exhibit P14. 14 is the pay. He deposed that the petitioner was working in his office as a distributor and trainer from 1 year 6 months prior to accident. The petitioner was paid rupees 12,000 to 15,000 per month. During the course of cross-examination of PW2, it is elicited that there are documents to show that petitioner was paid rupees 12,000 to 15,000 per month.
Now, after placing the documents, after examining the concern.
No, my lord, they have not produced any document.
Exhibit 14.
Your lordship kindly see that document.
What is
What
that?
they say, my lord, it is only a slip. It is not the salary certificate. And if he is paid, my lord, he has to prove his income. That was not placed before the court.
P14 is the income proof certificate.
My lord, before trial court, my lord, they have not taken this type of contention, my lord. They have accepted that.
Your case.
Why should
You
I
have
have
to
to
prove it.
adduce the
You have
negative
to-
evidence? It is your
Basing
duty
on
to
the proof,
establish.
Court will grant.
Please.
They are not coming before the court. Then you can say that they never took that contingent. You are coming before the court seeking enhancement.
Please, my lord.
Burden lies on you to prove that that is your income.
Please, my lord.
So vaguely somebody says 12 to 15 and for the 12 to 15, except a certificate, he should be, if he is giving you that amount,
Account
there should be
department.
some other supporting documents.
No, except that, my lord, he has not
Take
produced.
10 only, then it will
My
come
lord,
to
12,000 at least, my lord. 12,000 may be taken, my lord.
1,26,000 as it is. Then loss of amenities, how much is granted?
10,000 is
This
awarded.
10,000 is granted, my lord, another 20,000.
My lord, he was admitted to the hospital for 2 months, my lord. Another 20.
It is basing on your disability percentage, 30,000.
My lord, food and nourishment only 10,000 is awarded, my lord.
We have
10,000
granted,
is
sir,
granted.
60,000, 60 dinಕ್ಕೆ.
If you want, we'll make it 20,000. It's coming to 4,97,422. How much is granted?
3,77,422.
3,77,000.
422.
Please come. The appeal is filed by the claimant seeking enhancement of the compensation agreed by the award passed in MBC number 645 of 2016 dated 7th February 2018.
6%.
The claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the injuries sustained by the claimant. It is the case of the claimant that in the accident he had sustained
Crush injury on right foot. And
where do you get that?
Para
injury,
number,
issue number 2.
Para number 11, page number 6 of judgment, my lord.
That he had sustained a crush injury on the right foot of the claimant. He underwent surgery by nail fixation and discharged with follow-up treatment. He was in hospital for 2 months. And as per the evidence of the doctor, he had sustained 20% disability to the whole body and 7% disability to the
Limb disability 20%.
20% disability to the limb and 7% disability to the whole body. It is the case of the claimant that his salary is between 12,000 to 15,000. In support of his case, he had examined the employer. The tribunal had taken 10,000 as the income and granted the compensation. Next, parallel counsel, preparing for the claimant, submits that the compensation that is awarded by the court on all the counts is not a reasonable compensation. It is submitted that the court had failed to consider the 2 months hospitalization and also the fact that his income is between 12 and 15. Court ought not to have taken 10,000 as income, and as such, and even for the loss of amenities also, the amount that is granted is only 10,000. It is submitted that the compensation needs to be enhanced. Next para. Then counsel appearing for the insurance company submits that the tribunal had rightly considered and granted compensation. No interference is called for. Next para. Having heard the counsels on either side, there is a material non record. Considering the crush injury sustained by the claimant, this court is inclined to grant an amount of rupees 60,000 under the head of pain and suffering. Coming to the food and nourishment plus transport, he was in hospital, food attendant and transport. He was in hospital for 2 months and under the said head, he is entitled for an amount of rupees 60,000. Coming to the medical expenses, quoted, there is no dispute on the same and accordingly, no interference is called for. Coming to the loss of income during the later period, according to the claimant, his income is between 12 to 15. Court had rightly observed that though he has examined the employer, no other documents are placed before the court, and court had rightly taken 10,000. This court finds no reasons to interfere. When it comes to the loss of income during the later period, he was in hospital for 2 months, for the recovery another 3 months. altogether for 5 months is entitled for 50,000. Loss of future income, court had rightly considered 10,000 and disability at 7% to the whole body and granted 1,26,000. And this court finds no reasons to interfere. Coming to the loss of amenities, considering the disability, this court is granting 30,000. And towards legal expenses, in the light of so-and-so, 10,000. In the light of the law laid down in so-and-so, 10,000. Altogether, the claimant is entitled for an amount of rupees 4,97,422. Accordingly, appeal is partly allowed, enhancing the compensation from 3,77,422 to 4,97,422. Enhanced amount shall carry 6% interest.
Cell number 47, Kalyan R. Venugopal GM for appellant.
Appellant. Press short accommodation. Press short accommodation.
MSA of 2022, till now no stay. What accommodation you want? You that by this time, 3 years, the court after remand must have decided the case also. No representation on behalf of both the parties. This is matter on 16/4.
Some inconvenience.
It has been coming before the court, right from which year you filed it on 26/9/2022. The land counsel for the petitioner appellant shall file the status of the suit proceedings before this court by Wednesday. Wednesday, list this matter on Wednesday.
Yes.
Yes, next.
Cell number 48.
Here for the
Yes.
appellant, this is the appellant is the petitioner before the trial court in miscellaneous petition number
Has
3
to
of
be heard
2000.
finally.
Pardon?
This has to be heard finally.
Madam, it is not at finally, it is finally, it is the trial court. I am claiming the mean profits from the year 1993 to 2012 and 13. Totally, I have claimed 47 lakhs. The trial court awarded only 2,05,100 only for the period from the 2003. 10 years mean profits is not.
Case for the respondents.
Respondents is not represented, served notice unrepresented. And I prepared the appeal. The appeal in this court, there is a finding in page 37. Kindly see page 39, para 37. This court is opinion the trial court erred in not considering the entire claimant period for award of mean profits. The principles of justice and equity dictate the petitioners should be compensated for full duration of their loss. And in the light of the foregoing analysis, it is evident the trial court, its judgment contained certain errors and omissions. The limitation imposed on the award period. But matter is remanded back to only the question of remanding. I am questioning before this honorable court.
Please come to that order.
Let the trial court, it is a more senior judges is there in the first appellate court. Let them, there is already an evidence is recorded by the trial court based on the evidence.
Which para?
Para 37, page 39.
Para 30?
7, page 39. First appellate court findings. This court is of the opinion that the trial court heard in not considering the entire claimed period
The
for the
first
award.
point at hand pertains to the period for which mean profits were awarded by the trial court. The petitioner's claim spanned from 1993-94 to 2012-13. At the trial court restricted the award to the years from 2002 to 2003 to 2012 to 13 without providing a clear rationale for this limitation.
The trial court awarded only from 2012 and onwards. 93.
It is a suit in the year 1987. It reached to the Supreme Court also. And there
What
is,
is the evidence on record to determine this mean profits?
no, I have produced the,
Took it, come to the suit judgment and let us see what are the exhibits.
I have produced the certificate copy of the judgment and decree and possession property report of Bailey.
Where are you reading? Which page?
Page 77. Exhibit P5, price list issued by Tobacco Board. Market price list issued by Agricultural Department. Certified copy of his judgment in RSA 2019.
There are two issues. As far as the first issue is concerned, whether you are entitled for the mean profits or not, the appellate court said that you are entitled
I am
for the
entitled.
mean profits. Now what is left is the determination of the mean profits.
Yes, madam.
For that, the court felt that the trial court would do it in an appropriate way.
So the same could be done by the first appellate court.
But what are the documents? Basing on one, the certificate
No,
can
no,
it be done?
the respondents have not. The respondents have not produced it. In auction report, I have produced computer-aided RTC records. What is
By
the
this
going?
time, this, which year is this, when is the order passed by the court?
Madam, this is the first appellate, the trial court passed in the year 2000.
RA order?
RA order is in the year
Time it would have been completed.
2023, madam.
Court, by this time it would have completed your, what is the prejudice that is caused to you by remanding the
Madam,
matter?
going on remanding, it is.
Court had given a finding in favor of you that you are entitled for mean profits from a particular year to particular year, whatever you are seeking.
Yes.
It is always because the documents which you are showing and the years which you are seeking for mean profits, the court has to see every year there can't be any uniform price, 1990 and 2013.
The market list I have produced, what is the rate in every year?
There's nothing wrong in this order.
But the specific direction may be given to the trial court because there is already an order of this honorable court
Agreed with the
to
orders
dispose
passed
the main matter
number
with
6 of
a time limit.
11th September 2023, whereby the appellate court had remanded the matter to the trial court for consideration on the mean profits. The mean profits, the appellant is before this court. Originally, the miscellaneous number 3 of 2023, 3 of 2013 is filed with the appellant herein, and the court by order dated 9th December 2020 had allowed the same in part, and the respondents were directed to pay the mean profits for an amount of rupees
2,05,000
5,102.
against 47 lakhs.
It's also directed to pay the future mean profits as ordered to the appellant herein within 3 months from the date of the order, failing which the appellant is at liberty to refer the same from the respondents in accordance with law. Aggrieved thereby, he had filed file number 6 of 2022. That came to be allowed by setting aside the order of the in the miscellaneous and remanded the matter by order dated 11th September 2023. While remanding the matter, the learned judge, the appellate court observed that the appellant's claims spanned from 1993-94 to 2012-2013. And the trial court had restricted the award to the years from 2002-3 to 12-13 without providing a clear rationale for this limitation. And the appellate court has also observed that the trial court erred in not considering the entire claim period for the award of main profits. The principles of justice and equity dictate that the appellant should be compensated for the full duration of their loss. Then the court also observed that without the trial court's reduction of the yield per acre from 800 kg to 50 kg without adequate justification is not supported by sound legal principles. And had directed the trial court to decide the entitlement of the claimant, the entitlement of the appellant for the mean profits, and also had issued the directives that without further and directed the trial court to consider the evidence in respect of making calculation of the mean profits as observed by the court.
Page 43 in the operative portion, the specific date is also being given by the trial.
It is the contention of the land counsel for the appellant that when all the material is before the court ought to have determined the mean profits without remanding the matter. And remanding the matter will not serve any better purpose. It is submitted that the court, without considering all these aspects, had in a mechanical manner remanded the matter. Next, though notice is served on the respondents, no wakalat is filed on their behalf. This court, having heard the petition, counsel for the appellant peruse the material on record. The appellant is seeking mean profits from 1993-94 to 2012-2013. In that case, and the trial court had restricted the same for 2002-3 to 2012-13 without providing a clear rationale for the limitation. And even on the rates of that particular year also were reduced. And in those circumstances, the appellate court has felt that if the matter is remanded to the trial court, and the trial court, and also given a finding that he is entitled for the mean profits as sought by him. But however, to determine the quantum, the court had remanded the matter. This court is not able to understand how the appellant, how it is prejudicial to the interest of the claimant, and how he is aggrieved by the same. In the considered opinion of this court, the court had rightly heard the matter and remanded the matter, which is very much in the interest of the appellant. Already, when the order is passed on 11 September 2023, the appellant has approached this court, and from the last 2 years, the matter is pending before this court. Hence, this court deems it appropriate to fix a timeline for the trial court to dispose of the application accordingly. And the appeal is disposed of, directing the trial court to dispose of the matter within a period of 6 months. 6 months, as per the procedure, as observed by the appellate court in paragraph number in the operative portion, that is point number
1 to 4, 1 to 7.
2 to 7. Yes.
Number 49, Akash Kumar Gowda, for appellant.
I appear for the appellant, my lord. My lord, I have challenged the order of the land appellate court, my lord. The land appellate, there is a settled law, my lord. that matter cannot be remanded to incorporate new pleas. However, my lord, the trial court has come to the conclusion that I am in the possession of the property, and the respondent have also admitted.
What is that? What are the facts of the case?
My lord, they have sought for, my lord, they have challenged the sale deed, my lord, as well as they have sought for not to extract land.
Suit for declaration.
Suit for it, they have not, they have sought for suit for declaration without seeking possession, my lord. In the judgment.
For declaration that the sale deed is not binding on them.
Please, my lord.
Or the
My lord,
cancellation of the sale deed.
I have a cancellation of this. I have executed a sale deed in favor of the.
Let us see what is the prayer that is sought.
Please.
Without that, you can't go further.
Please, my lord. My lord, at page number 42, my lord.
Seeking to declare the sale deed executed by the first defendant.
In favor of the second defendant.
In favor of second defendant.
Is null.
Not bind in any way on the plaintiff.
Please,
and others, and to restrain and sought for a consequential
injunction and not to extract. Now, my lord, the trial court has come to the conclusion that I am in the possession of the property. Based on that findings, my lord, after the judgment has been passed before the appellate court, my lord, they have remanded back the matter to the trial court to incorporate that case.
What happened to the suit?
Suit has been dismissed.
Dismissed. Please come to the order of the operative portion of that or the relevant finding.
Please. My lord, the operative portion, my lord, in my
Operative in the sense, where is the relevant finding?
Relevant findings, my lord. I will need to go to the entire findings, my lord, because, my lord, there are issues at page number 42, my lord. Whether the plaintiff prove that he is the absolute owner in possession of. So issue number 1 to 3 speaks about whether I am in the possession of the property or not, my lord. Issue number 1 and 3. The plaintiff at page number 48, the plaintiff has claimed that he is the son of S.C. Virupakshaya. His father S.C. Virupakshaya is adopted son of Sir Chikkamallappa. Said Sir Chikkamallappa is the brother of Sir Dodda Basalingappa. It is also stated that Sir Dodda Basalingappa is a biological father of S.C. Virupakshaya. Therefore, he is the absolute owner of the suit property. On the other hand, the first defendant also claimed that he is the defendant of Sir Dodda Basalingappa. Hence, he succeeded to the suit schedule property. Therefore, issue number 1 and 3 are interlinked in order to avoid repetition of the facts and the reasons these issues are taken together for common discussion. It is not in dispute that the suit schedule property originally belonged to Sir Dodda Basalingappa. It is not in dispute that Dodda Basalingappa had purchased the suit schedule property on 5/4/1917 through registered sale deed from Sri Veera Raje Aras, Lingappaji Puttaswamy and Dodda Raje Aras. Since the plaintiff and the first defendant claim that the Sir Dodda Basalingappa is their prepositors, considering of the genealogy of both the party is vital to the case. Let me appreciate the evidence of both the parties. The plaintiff has pleaded that Sir Dodda Basalingappa has younger brother by name Sir Chikka Basalingappa. Sir Dodda Basalingappa has got 3 sons, namely S. Prabhuswamy, S.C. Puttappaji and S.C. Virupakshaya. Since Sir Dodda...
Please come to the appellate court sort.
Appellate court. At page number 34, my lord. IA number 1, filed by the appellate under order 41 rule 3A of CPC, read with section 5 of limitation is allowed. The regular appeal filed by the appellant under order 41 rule 1, read with section 96 of the CPC against the judgment and decree of the trial court of civil judge T. Narsipura dated is allowed with cost. IA number 2 to 5, filed by the appellate under orders 6 rule 7. This is an amendment application, my lord. An amendment application at the stage of appeal may not be entertained, my lord, because it is a settled law. Order 1 rule 10 class 2 read with section 151 of CPC and order 41 rule 27 of CPC respectively are allowed on cost of rupees 5,000, which is to be paid by the appellant to the respondent. Number 2, the judgment and decree of the trial court is set aside. The case is remanded to the trial court for fresh disposal. The trial court is to permit appellant to amend the plaint, add the proposed defendant to the suit and produce the document in evidence as prayed in IA number 2 to 5. My lord, it is a settled law, my lord. Cause of action will change. Before the learned appellate court, the learned appellate court cannot remand the matter back to the trial court and direct the trial court to incorporate new pleas. There are several judgments, my lord, which says that the higher courts cannot remand back the matter to incorporate new pleas, which also changes the nature of the suit as well as the cause of action. And my lord, there is an admission by them, my lord, since from the year 2004, I am in the possession of the property. In spite of that knowledge, my lord, they have not sought for the possession when they had filed a suit. And from the year 1970, my lord, my name has been incorporated in the revenue entries. Even the revenue entries have not been challenged. And I'm in the long possession of the suit schedule property. Moreover, my lord, Article 65 applies. Within 12 years of time, they have not sought for possession also.
The present appeal is filed, agreed by the order passed in RA number 39 of 2020, dated 1st October 2024, whereby the court had remanded the matter to the trial court, permitting the plaintiff to amend the plaint as prayed in IA number 2, to amend the plaint and to add the proposed defendants as prayed in IA number 3, and to produce the documents in evidence as prayed in IA number 4 and 5. And in the meantime, the trial court has liberty to give an opportunity to the defendants to lead additional evidence, if any, and also to cross-examine the plaintiff. In the suit filed by by the respondent herein, who is the plaintiff, has been dismissed on 2 grounds. One is that all the owners of the property are not non-joinder of the proper and necessary parties. And number 2, the plaintiff has not sought for the relief of declaration, the relief of recovery of possession, the recovery of possession. Now, before the appellate court, he had filed an application seeking amendment of the pleadings and to plead the other parties, and also to amend the other parties, and also to seek the amendment of the prayer, and for that the matter is remanded. Land counsel appearing for the petitioner submits that such a course is not permissible for the appellate court, and permitting the plaintiff to fill the latches on his part, and such a course is not available to the appellate court. This court has perused the order passed by the trial court as well as the appellate court. Prima facie, it appears that the appellate court had remanded the matter beyond the jurisdiction conferred on the court and exercised the discretion beyond the jurisdiction. Accordingly, there shall be stay of all further proceedings. Invoice number 221 of 2009, dated voice number 221 of 2009, till the next date of hearing. Hand summons.
We'll take out.
A memo shall be filed by 4th of August. If the memo is filed, list the matter on 5th, or else the stay granted by the court stands vacated.
Much
Yes, next.
for final hearing. CL number 50, Gopal Krishna N for appellant, T.S. Reader.
Council and record is not in station today, my lord. Kindly have it on tomorrow.
Tomorrow.
Yes.
CL number 51, A.N. Krishna Swamy for appellant.
Yes, Mr. Krishna Swamy, on what ground?
My lord, fraud case, these are two. Though the compensation awarded is 75,000, in another case, 69,000. My lord, the connected matter 6624 of 2014 is not listed. That also could be listed. And some of
We'll do this and the same order will follow.
that also.
Because you are here, somebody should argue.
But in fact, some of the documents are in Kannada. I think
Judgment is in,
judgment is in English.
we'll see. If required, then we'll adjourn.
Because the superintendent of police, after receiving a complaint from the insurance company, he has given a report that a fraud is committed in implicating this vehicle. That is in Canada. That is the reason I wanted.
He was examined.
So circle inspector is examined. He has submitted that report also.
So now let's go to the order.
Melody.
Where are these findings? Para 14.
Melody, yes.
Further on perusal of exhibit R5, which was submitted by IGP East Circle.
Oh.
What is the vehicle involved?
Melody, the two-wheeler, one more two-wheeler is involved. But they have implicated one motorcycle, which according to police also.
No, the claimant was traveling
He was a rider and pillion rider of a motorcycle.
motorcycle. What is the other vehicle?
The other vehicle is also, according to them, is a motorcycle.
According to you, it is not, according to the insurance company,
My lord,
that is
this
not involved.
My lord, they were traveling in KA 16Q8987. And they contend that KA 16R1285, another motorcycle dashed against the said motorcycle. KA 16 R1285. And this 1285, police would file charge sheet against the rider, and subsequently the superintendent of police, after holding inquiry, holds that this vehicle was not involved and fraud is committed. And he has sent a report to DIG to take action against concerned persons, police, who have filed the charge sheet.
Then what happened to that criminal case? They filed the same
My
report
lord,
before
these
the court?
in criminal courts, they injury cases, they have accepted, plead guilty. They plead guilty for a offense and pay fine. This is managed by claimants.
No, that's true. What I'm saying is, when a person has done all this exercise and sent to the DGP, by the time the criminal case is pending or not?
It was not pending. My lord, it was.
When
That I have to examine it.
By the time the case was heard.
Immediately it was heard. And without notice to insurers, criminal cases would get disposed of. Subsequently, we lodged a complaint that a false complaint was
So
lodged.
let's
Because
read-
normally,
Let's read
Well,
the order. Let's read it from the issue number 1.
my lord,
Issue number 1.
issue number 1, yes, my lord, that is the one. My lord, para number 12, according to MACT,
Yes.
this is what they have contended. My lord, my lord, I will come to the
These are
portion in para
both
8,
the
page
claimants
8.
are rider and the pillion rider.
Rider and pillion rider, both of them. ಈ ಪ್ರಕರಣವು ನ್ಯಾಯಾಲಯದ ವಿಚಾರಣೆ ನಡೆದ 15/11/2010.
You are reading that Kannada part.
He has pleaded guilty and he has paid 1,600 rupees as fine.
Yes.
And further on perusal of exhibit para 30 R5 dated 12/1/2012, which was submitted to IGP East Circle, Davangere, by the Superintendent of Police, Davangere District, Davangere, as clearly stated in page number 4, third to fourth para. My lord, it is once again in Kannada. Sadari Santebennur ಠಾಣೆಯ ಗುನ್ನೆ ನಂಬರ್ so and so ಎಂಬ ಪ್ರಕರಣದಲ್ಲಿನ ದಾಖಲಾತಿಗಳು ಮತ್ತು ಹೇಳಿಕೆದಾರರ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಗಿನಂತೆ ಅಭಿಪ್ರಾಯಕ್ಕೆ ಬರಲಾಗಿದೆ. ಸದರಿ ಪ್ರಕರಣದ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಗೂ ಸಾಕ್ಷಿದಾರರ ಹೇಳಿಕೆಗಳನ್ನು ಗಮನಿಸಿದಾಗ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಮೋಟಾರ್ ಸೈಕಲ್ ನಂಬರ್ KA16R1285 ಅಪಘಾತಪಡಿಸಿರುವುದು ನಿಜವಿದ್ದು ಅದರಂತೆ ಆರೋಪಿ ಉಮಾಪತಿ ಈತನ ಮೇಲೆ ದೋಷಾರೋಪಣಾ ಪತ್ರವನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ್ದು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆರೋಪಿಯು ತಪ್ಪನ್ನು ಒಪ್ಪಿಕೊಂಡಿದ್ದರಿಂದ ದಿನಾಂಕ 15/11/2010 ನ್ಯಾಯಾಲಯವು 1,600 ರೂಪಾಯಿ ದಂಡ ವಿಧಿಸಿದ್ದು ನಿಜವಿರುತ್ತದೆ. It is clear that though the respondent number 2 denied the involvement of offending vehicle in the accident and taken place contention.
No, what is this? What you read in Kannada now?
They say that detailed inquiry was conducted and thereby it is held that this vehicle is involved in the occurrence of accident 1285. That is the reason why he has pleaded guilty. That is what the stand taken. My lord, I read the next paragraph.
No, para 13 is the report of the IGP.
My lord,
Para 13 is the report of the IGP.
my lord,
That
my lord,
is,
this
that
is
must be in
which
your
was
support.
submitted to on exhibit R5 dated 12/1/2012. Submitted to IGP circle. My lord, I read the next para. R3 prakara, my lord, para 14. May I read it fully, completely. It is clear that though the respondent number 2 denied the involvement of offending vehicle in this accident taken place of the contention that the accident was occurred mainly due to rash and negligent driving of motorcycle bearing number 8987 by its rider. Further, the respondent number 2 has also taken up the contention in collusion with the police. The petitioner have created false documents by producing exhibit R2 investigation report. Further, when the question was put to PW1 and PW3 in this regard, that the accident has occurred due to rash and negligent riding of motorcycle bearing number so and so by its rider, but they have denied the same and nothing has been elicited. To support the case of the respondents, after their revision petition is allowed and examined RW2, D. Prakash, who is SP of Davanagere district, in their support, but he has not come forward to say in favor of respondent number 2. As such, he was declared as hostile and cross-examined at length. Exhibit R3 ಪ್ರಕಾರ ಅಂತಿಮ ವರದಿ ಸಲ್ಲಿಸುವ ತನಿಖೆಯಲ್ಲಿ ನ್ಯೂನತೆ ಇತ್ತು ಎಂದರೆ ಸತ್ಯ. There was defect in filing of charge sheet, he admits. ಈ ಬಗ್ಗೆ ತಪ್ಪಿತಸ್ಥರ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಬೇಕು ಎಂದು ಉನ್ನತ ಅಧಿಕಾರಿಗಳಿಗೆ ವಿಮಾ ಕಂಪನಿಯವರು ದೂರು ಸಲ್ಲಿಸಿದ್ದರು. There was a complaint lodged against this particular investigating officer for having filed such a complaint is true. ಆದರೆ ಮೇಲೆ ASP ರವರು ದಾವಣಗೆರೆ ಗ್ರಾಮಾಂತರದವರು ತನಿಖೆ ಮಾಡಿ SP ರವರಿಗೆ ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. A report is also given to the superintendent of police. ನಂತರ SP ರವರೇ ಸ್ವತಃ ತನಿಖೆ ಮಾಡಿ thereafter SP himself has conducted the inquiry ಮಾಡಿ ವರದಿಯನ್ನು IGP ಪೂರ್ವ ವಲಯದವರಿಗೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಎರಡು ವರದಿಗಳನ್ನು ಗುನ್ನಾ 79 of 2008 ಇಲ್ಲಿ ತನಿಖೆ ಕಾನೂನು ಪ್ರಕಾರವಾಗಿದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆ ಕುರಿತು ಎರಡು ವರದಿಗಳ ಕಚೇರಿಗಳ ಪ್ರತಿಗಳನ್ನು ಈಗ ಹಾಜರುಪಡಿಸುತ್ತಿದ್ದೇನೆ. ಅವುಗಳನ್ನು ಕ್ರಮವಾಗಿ ನಿಶಾನೆ R4 ಮತ್ತು R5 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. These are the two reports. According to them, it was done in accordance with law. That is what the report of IGP. It clearly shows that the driver of the offending vehicle is prosecuted for the offense punishable under section 279 so and so, and the driver of offending vehicle was pleaded guilty and has paid. Therefore, they have report of superintendent of police exhibit R3 mechanism.
That's what is.
That is what
you
they
read.
have extracted it. Ultimately, the court holds that basing on the report and also plead guilty, insurer is liable to pay the compensation.
What is the further action? What is the further action by the police against the officer, or they should for a malicious prosecution they should have filed a case against that person, against the claimants.
Those details.
So just a report without the concern. Unless and until the author of that is examined, as generally argued by the insurance company,
My lord, this superintendent of police who is examined,
He
he's,
didn't
my lord,
support
if I
your case.
read the deposition,
Hmm.
it should not have come up from the mouth of an SP.
Hmm.
My lord, this is what he states. DIG ಗೆ ಕಳಿಸಿ ಕೊಟ್ಟಿದ್ದರು. ನಿಶಾನೆ R3 ಪ್ರಕಾರ ಸರಿಯಾದ ತನಿಖೆ ಆಗಿಲ್ಲ ಎಂದರೆ this session ಸರಿಯಾದ ತನಿಖೆ ಆಗಿದೆ ಎಂದರೆ ಅದರಲ್ಲಿ ಸಂಪೂರ್ಣ
Is it the report submitted by you? Is it the question?
Exhibit R3 is a report submitted.
Is it the question? Is it the question put forth to him that exhibit R3 is a report submitted by you?
Yes.
What he says?
He says ಸಂಪೂರ್ಣವಾದ ವಿಚಾರಣೆಯಾಗಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತೆ.
Means?
Completely it is not investigated. This is what the answer superintendent of police gives.
That is sufficient for your case. This is which embassy? What is there?
My lord, first.
And the connected number also will come in the afternoon.
Oh,
Get that
6624. 6624.
6624 also get it.
My lord,
I'll pass order in
one
this.
submission is earlier. Compensation was determined at 22,000, 26,000 and 63,800. I filed a review petition. Thereupon it was recalled. Subsequently, compensation is enhanced.
In which case?
In both the cases, my lord,
Both the cases by the trial court.
by the trial court, this happens. Mindset
What
of
is the
another
scope of-
presiding officer would favor the claimants.
What is the scope of review?
In fact, we were expected when a fraud is committed, I have to make an application before MACT alone. I filed it. That was allowed.
No, there are two different orders, is it not? One order, compensation is this much. Other order, the compensation is that much. So you're happy, you're not happy with the first order.
I was not happy as far as saddling of liability on me was concerned, an insurer, without looking into the fraud angle. And once I bring it to the notice
For
of
that,
MACT,
one appeal is sufficient against the review order. Technically.
my lord, it merges, yes, it merges. This appeal, all interim orders, all orders passed by the court would merge.
Review is not an interim order.
My lord, earlier order was there determining the compensation. They allowed me. I am not aggrieved by allowing of my.
No, original order is against you, review order, both are against you.
No, review order is in my favor. In fact, by filing a review before MACT, my application was allowed. And once again, the cases were restored earlier.
And thereafter? No, we are concerned with the final order. So that order is set aside.
That order is set aside and permission is granted to lead evidence. I
And
led
this is
evidence.
so there is only one order.
In the same MACT, yes. My lord, I have narrated it in my brief facts. My lord may kindly look in.
No, when
The
review
tribunal
is filed-
proceeded to pass judgment and award and granted compensation of 63,000 in favor of claimant in MEC 510 of 2008 and a sum of rupees 26,000 in favor of claimant in MEC 509. The said judgment was pronounced by the
Where do
tribunal.
you get about this discussion about the earlier order and all in this order?
This order. The petitioners,
It says as if it is dealing with it for the first time. The court discussion is as if it is dealing with the case
for the first time. My lord, as per, since these petitions are arising out of the same accident, they are clubbed and they are disposed of under common judgment 27/7/2000. The parties case, in fact, they narrate the respondent's notice for served. No discussion with regard to the
Earlier order.
earlier order.
Where is the enhancement? No discussion. Please come.
I lose the case.
So this is MDC number 50.
My lord, 6626.
What I'll do is I'll dictate for both. Let that case be called in the afternoon.
My lord, 6626 arises out of MVC 510 of 2008. 510.
Is a pillion rider or rider?
My lord, he was a pillion rider.
The rider and pillion rider. Right.
Rider and
Agreed with the orders passed in MBC number 509 of 2008 and 510 of 2008, dated 25th day of June 2015. The insurance companies before this court by filing MFA 6626 and 6624 of 2014. The claim petition is filed seeking compensation of an amount of rupees 3 lakh and 5 lakhs for the injuries sustained by the claimants who are the rider and the pillion rider. It is their case that the claimant in MBC number 509 of 2008 was riding the motorcycle. And the claimant in MBC number 510 of 8 was a pillion rider. At that time, they were going on motorcycle bearing registration number KA16Q8937 from Harihar to his native place. And because of the rash and negligent driving of the rider of the motorcycle bearing registration number KA16/R1285, both of them have sustained injuries. The insurance company has denied the involvement of the said vehicle, and in support of their case, they placed before the court Exhibit R3, that is a report submitted by the Superintendent of Police to the DG. And as per the same, the said vehicle is implicated in this case and there is no involvement. And in fact, yes, the action is initiated against the police officer who has conducted the investigation. The tribunal had held that the author of Exhibit R3, SP, has not supported the case of the insurance company, and the said evidence was not considered by the court. Then coming to the remaining evidence, the driver of the opposite vehicle had pleaded guilty and the court had convicted him, has imposed fine, and accordingly held that the insurance company is liable to pay the compensation and granted compensation of an amount of rupees 65,000 and 78,000 respectively. The land counsel appearing for the insurance company submits that the claimants have played fraud on the court, and it is supported by Exhibit R3. The trial court had failed to consider the said document, and the persons who have come to court with unclean hands are not entitled for any relief from the court. It is submitted that the tribunal, without considering all these aspects, had granted the compensation. Next paragraph, though notice is served on the respondents, no wakalat is filed on their behalf. It is having heard the learned counsel for the petition insurance company for the material on record. It is a case of the insurance company is relying on Exhibit R3. This court had perused Exhibit R3 and also evidence of he is examined as
PW2, RW2.
Yeah, and evidence of RW2. It is evidence of RW2 that the investigation is not concluded and it is yet to be conducted, yet to be completed, and he has not supported the case of the insurance company. In the considered opinion of the court had rightly disbelieved, has not considered the said evidence, and basing on the other evidence available on record, had held that the accident has happened because of the rash and negligent driving of the driver of the opposite vehicle and rightly granted the compensation. This court finds no reasons to interfere. Accordingly, both appeals for the insurance company are dismissed and the amount and deposit shall be forthwith transferred to the trial court.
Even
What happened to your Passover matter?
I see Mr. Chinnappa outside. They are there outside. May I just call them?
Yes.
I believe Mr. Chinnappa is in.
Yes.
end up in another court in the morning.
Yes.
List 1.
List 2.
List 2, serial number 25.
So what is this amendment petition that is filed now?
Lord, in the amendment, we are actually, may I just pass it on? This, of course, deals with one part of an objection. Of course, I must admit, my Lord, an objection raised by my learned friend that there is no maritime claim that is made, and we've only asked for security insofar as an arbitration proceeding pending in London. That, my Lord, was one objection that was raised. While, my Lord, I don't entirely admit to that position as a position
No,
of
before
law.
going into that,
Yes.
please come to the prayer that is sought.
Yes.
Where is the prayer?
Please take note, page 37.
Yes. Yes, please read the prayer.
Directing the respond vessel CS Flourish together with the hull, engines, gears, tackles, bunkers, machinery, plant and machinery, at present lying at New Mangalore Port Trust or wherever she is within the territorial waters of India, be arrested by an order of this honorable court as security for the payment of the petitioner's claim pending in arbitration proceedings amounting to sum of rupees 1,615,000 and euro so and so and cost of so and so, along with interest at the rate of 18%.
So ultimately, what is the dispute that has to be decided by this court?
Lord, really, my Lord, there are two parts. In any Admiralty proceedings, your Lordships are looking at a maritime claim. A maritime claim can be made, of course, before your Lordships, because unlike any other law which deals with cause of action, your Lordship's jurisdiction is vested as soon as the ship comes within the territorial jurisdiction of your Lordship's court, and not India. So I can go maybe to Gujarat, Bombay, Chennai, Cochin, and all these other states which have been invested with jurisdiction because there is a coastline there where the ship comes. So as soon as the ship hits the territorial waters, your Lordships will not exercise jurisdiction over the ship. Therefore, I am entitled to then make a claim, which is we call it as a maritime claim, with respect to an amount that I am entitled to by, my Lord, ultimately possibly a sale of the ship or otherwise. Because once your Lordship arrests the ship and it comes within your Lordship's jurisdiction, it becomes an action in rem. And an arrest could result in a scenario where other persons may also come and make claims with respect to the ship. And then your Lordship may ultimately decide, after trial, of course, as to whether the ship should continue or not. Or one person, as has been done in this case, you can provide security for the entire amount of money, have ensured that the ship is released. The ship is now released. And the amount is secured by virtue of a bank guarantee or a deposit before your Lordship's note, which is what has happened in this case. Therefore, whether an Admiralty proceeding can be initiated simply for the purposes of obtaining security, or whether there must be also a claim for money actually made, is one question. There are two views on the subject, and I'll point out our Karnataka High Court has taken slightly different view on the subject, which is upheld by the division bench and pending in Supreme Court on an arbitration proceeding itself. And whether, my Lord, I must make a claim. Therefore, I don't want to get into that argument as to whether you should actually have a claim that is pending before this court and also in arbitration with respect to a maritime claim.
Not like that. No, whatever the arrest of the ship and other things, it is like it's an interlocutory application where you are seeking the main relief would be has to be there before the court. Court is not like just for what purpose the court is arresting the ship.
Lord, yes, I see what your Lordship is saying, which is what I was also thinking. One of the reasons why we also amended it, Lord, is because it's a little uncertain in so far as the law is concerned.
So ultimately, the claim will be decided by an arbitrator, and
that
will be for what reason the court is arresting the ship.
No, yes, my Lord. What seems to be one position seems to be, my Lord, that you must make a claim here for the entire. That is, the entire claim should be made here and also in arbitration. But this court, after the arrest of a ship, will stay its own hands until the arbitration is decided. That is one approach, my Lord, which the Bombay High Court has taken, saying there's a claim before us, but obviously we can't decide that claim, Lord, because otherwise it becomes a very complicated situation. There is an arbitration claim going on somewhere. There is a maritime claim being made here. Your Lordships also can decide. The arbitrator also will decide. You can't have a scenario of both kinds. Therefore, it appears Bombay High Court's view, my Lord, seems to be that they will hold back these proceedings until the arbitration proceedings are decided, and then come back to give effect, my Lord, possibly as if it's an executing court to that claim. That is one part of it. Whether the proceedings under this is almost Section 9 can't be done, my Lord, for ships. We cannot initiate Section 9 action and arrest the ship. Therefore, I must exercise or request your lordship to exercise Admiralty jurisdiction to give me security. Now, Admiralty, my lord, as such, is ultimately done almost with the consequence of ensuring that all over the world, different countries will aid a claim that is being made, though the claim has never arisen in India. Therefore, if your lordship ask me a question, how would your lordship exercise jurisdiction between two completely foreign parties? Your lordships will never be able to exercise jurisdiction over two foreign parties because there's nothing that has happened in India. None of them, my lord, are within your lordship's jurisdiction, except the fact that the ship has come.
Ship is here.
Ship is here.
And whatever concerning the ship, what are the disputes with regard to that? That has to be decided by the court.
No, there, of course,
That's correct. Subject to what my friend
Let
says.
him continue.
of course, anything to do with the ship, my lord, ultimately is the objective. But the ship by itself may not be in dispute. In the sense, ship may act as some form of a security in respect of a monetary claim.
Yes, that is a claim between two
The
parties.
claim between two parties. In this claim, my lord, my claim is against respondent number 3, who, my lord, is the one with whom I had a charter party agreement, who was supposed to charter the ship in my favor, did not charter it, and therefore I was not in a position to take the ship, owing to which I suffered some losses. Therefore, I have made a claim against them in a court, before the arbitral tribunal, my lord, which is to be constituted or is in the process of being constituted. Now, the question, my lord, first,
Your claim is against
respondent number 3.
Continental Dry Bulk Limited.
Yes. Because the agreement was with them to give this ship. The agreement was not for something else, but an agreement to give this ship on a time charter for us for a period of 6 months, so that we can then utilize the ship to transport goods, my lord, to various parts. And I had future contracts or further contracts with various parties, owing to which I suffered losses, and that became a maritime claim, which I then made. That is a substance. Therefore, in terms of what claim I have, I would respectfully say that that claim is also against the ship, because ultimately, my lord, it was this ship that had to be given to me for the purposes of carrying out a time charter. Today, my lord, if your lord, as you typically, my lord, in a Section 9 application, as your lordship see, a Section 9 does not have a main result. It only deals and determines the question of whether an interim relief can be granted, and then your lordship dispose of the Section 9 proceedings there itself. In this case, of course, your lordship will take this through trial to see as to whether ultimately this claim should be granted or not granted.
So what is the trial to be done? In
The trial also will be at best at this stage, my lord, to see as to whether this security should be there in respect of this property which we have now got within the custody of the court, with respect to a maritime claim which should be decided by the arbitration and not by this honorable court ultimately. Because the case law, at least in Bombay, my lord, which my learned friend relies on, seems to take the position that even if you make a claim here, this court will not adjudicate it, but will await the decision by the arbitral tribunal and then give effect to it later.
Yes.
That not seems to be, but first let me point out one judgment of our High Court which has been upheld by the division.
Yes.
May I pass on?
MV Emirate.
Global Emirate. Everything is
Small word.
Yes.
Yeah.
And where is the division bench judgment?
I'll give you lots. The division bench upheld it. It's pending in Supreme Court now. Division bench orders here. May I just request me to kindly take
Yes.
page 10, my lord. Page 10. Sorry. Oh, which one did you get? Oh, I'm so sorry. I think I'm
Single judge.
I think 2 copies are here.
Oh,
I've given
I
2
think, my lord, by
copies.
mistake, we've given the.
My lord wants the single judge, and that's all. I have the single judge.
MEC or global?
Sorry.
No, Justice Sunil.
MEC.
but the
MEC.
other-
That's correct.
Single. I had the division bench. I'm sorry.
No
Division bench is. I'm sorry. I was wondering why para 10 was not matching.
Yes.
Page 10, para 23
Of the DB.
of the single judge.
Single judge.
My lord may I just take your lordship through that judgment? Arrest as a security till arbitration proceedings are concluded. It must be noticed arrest of the vessel pursuant to the action in rem is an accepted remedy till conclusion of arbitration proceedings. Legal position is enunciated in the case of CM offshore, report and so on. So High Court of Bombay has followed the observations full bench in the case of JS Ocean Liner. Observations para 78 are as follows. We shall accordingly articulate our conclusions thus. An application under Section 9 of the Arbitration Act is not maintainable for the arrest of the vessel for obtaining security of an award that may be made in arbitration proceedings. The view to the contrary in ME Indura so and so is overruled. An action in rem for recovery of the claim and arrest of the vessel where the parties have agreed to submit the dispute to arbitration can be maintained. And in such a case, by way of an interim measure, the vessel is arrested or the security provided is to obtain the release of the vessel. Matter shall proceed in accordance with Article 7 of the International Convention. If the proceedings are brought within the time so ordered by the court before the arbitral tribunal, any final decision resulting therefrom shall be recognized and given effect with respect to the arrested ship or to the security provided in order to obtain its release, provided that the defendant has been given reasonable notice of such proceedings and a reasonable opportunity to present the case. With regard to clause 2 and 3, it is clarified retention of security should remain a matter of discretion. Then CM offshore. Reasons given by the full bench for its conclusions articulated in para 78 are extremely important. These are set out in para 72, 73, and 77. Of particular importance is what the full bench has stated in para 73, which reads thus. Application of Article 7 of, I'm sorry, got that, no? Page 12. Page 12. I don't know if your lordships have gone ahead or not. I won't read it again.
I'm at para number 25.
25. Oh, that's the conclusion of the
Yes.
court. Yes, I'll read that because that is where there's a maritime claim, which in the present case is stated to be a claim against the vessel arising out of supply of goods, bunker fuel. Same would fall within the maritime claim as envisaged under Section 4(1) of the Admiralty Act. In such a case, an action in rem for arrest could be initiated. Though, as in the present case, the dispute could be adjudicated before the arbitrator in light of the arbitration clause in terms of the observation of Bombay High Court extracted above. An action for arrest to obtain security till arbitration proceedings are concluded is maintainable. The exposition of the law by the Bombay High Court merits acceptance without any reservation. Irrespective of the finding recorded relating to institutional proceedings in second instance, an action for arrest could be maintainable on consequent occasions, as and when the vessel enters the territorial jurisdiction. Movement of the vessel in and out of the territorial waters itself would be construed to be successive fresh causes of action to initiate proceedings for arrest in an action in rem. If that were to be so, even if it is held that a second round of litigation is instituted seeking arrest of the vessel, when on an earlier occasion proceedings have been withdrawn, it can be stated that the second round of litigation seeking for an order of arrest in light of the maritime claim would be permissible as and when recurring causes of action arise, namely whenever the vessel enters the territorial waters. Accordingly, though earlier petitions were filed in so-and-so which came to be withdrawn as the vessel had not docked within the territorial waters of the court, it would still be permissible for the petitioner to maintain the petition. So the same maritime claim has sought to be put forward in CP number so-and-so when the vessel re-enters the territorial waters, giving right to a fresh cause of action to seek for arrest. The right to seek for arrest as security pending adjudication and arbitration proceedings would continue to be invoked every time the vessel enters the territorial waters and would be a recurring cause of action.
Yes.
And then ultimately the order of arrest was confirmed after hearing the parties. Then the para 41, the court says accordingly the final adjudication is won during trial 41 and the applications filed by the respondents are rejected. As the present action is won in rem, maintenance of the vessel and costs to the post authority is to be borne by the respondent till conclusion of proceedings.
No, here, if you see the release at page number 2, paragraph number 2.
Yes, ma'am. Yes.
There is a
to pay a sum of one
that has to be decided by this court. In the
no, that's where my lord, your lordship will see what the High Court has said. Ultimately, though, my lord, it is not very difficult to make a claim today, my lord, insofar as an Admiralty proceeding is concerned, because really there's no court fee there. And insofar as Admiralty proceedings in terms of rules, no rules have yet been made, and nor has it been said that a particular court fee will have to be paid, and there's a specific fixed court fee which is paid. Therefore, to make a claim really is, in my humble submission, of little difference to anyone, because in this proceeding also a claim was made. In earlier proceedings also, not we made claims.
It's an occasion for the court to say
Yes.
that there is nothing. With regard to that pending arbitration proceeding.
Yes, that is, my lord, what the court said at para 28. Because it said, your lordship will see it was not a security pending adjudication of these proceedings for money. It was security pending adjudication of the arbitration proceedings. Para 28.
What I'm saying is,
yes,
such a scenario has not come before the court in this case.
It was. Here also there was an arbitration proceeding. Here also, my lord, because your lordship sees the question at page 10. Please see the question. Page 10, my lord.
In this particular case.
In this
the
case,
facts, please show to the court.
my lord.
That the arbitration proceedings are pending.
Yes, my lord. Yes. Can I request my lord to look at um, page 10, the question itself. Page 10, the question on top, my lord. Right at the top, the heading. I'm sorry, I don't know if my lord has the same.
No, that's the whole difficulty. An issue is framed.
Yes, that's because
The facts were, like
petition
this
is
issue of pending arbitral proceedings is nowhere in the facts. If you look at the facts.
yes, my lord. Please see page 16, first paragraph.
Page 16.
Page 16, first paragraph.
Mm.
In such a case, I'm sorry, in such a case, an action in rem for arrest could be initiated, though as in the present case, the dispute could be adjudicated before the arbitrator in light of the arbitration clause in terms of the observations Bombay High Court excited above. An action for arrest to obtain security till arbitration proceedings are concluded is maintainable. This is the question, Lord, as a matter of fact. And the prayer is at page 3, prayer C. To order that the vessel along with the hull be sold and proceeds from such sale be applied as a security to ensure that the award would be satisfied. As a matter of fact, my lord, I think you only appeared. My learned friend appeared in that proceeding as well. She's only maritime lawyer in Bangalore. And it was also a case where there was an arbitration clause and therefore security towards the arbitration was sought. This, my lord, was then challenged before the division bench. I think handed over that judgment to your lordship.
It's here.
Yes. The division bench not then considered this question. No, this. Ultimately, my lord, it's para 28 at page 17. Prima facie case means it should not be vexatious one or totally untenable. Material on record did not show that the case of the appellant was a vexatious one, but the rival containing documents produced on either side show that there is a case to go for trial and ultimately dismissed. And 35, para 35, learned single judge on a judicious appreciation of all the contentions raised by the parties and the material placed before it has passed a well-reasoned order. No speck of arbitrariness or perversity is found in the order. Therefore, the appeal is dismissed.
Yes.
This, my lord, is now pending in the Supreme Court. I understand there was a direction to them if they wish to avail of, if you want to take the ship to provide security. I understand security has been given and the ship has thereafter set sail.
And please come to this amendment.
Yes, my lordship may kindly take my amendment application. Give me the amendment application. My lord, if my lord kindly comes to para 60A onwards, the amendments are to also put in, my lord, this figure of 1,615,000 and the claims, my lord, which are really pending in arbitration. And para 60C.
Certain pleadings which were not taken earlier and by way of this application.
Yes. Before trial, my lord, these.
And with regard to the earlier proceedings
in
for the
Russian court. And the prayer also, my lord, is there. But this prayer really, in my respectful submission, and I don't think my learned friend also deny, ultimately that prayer your lordships will never consider and grant. Because if I lose in the arbitration, for instance, then, Lord, the question of me coming here and asking your lordship to adjudicate on it again does not arise.
Yes.
With this amendment, my lord, being a pre-trial amendment, really, in my respectful submission, may be considered. Because if, my lord, really, if they are going to argue that this petition on the face of it is not maintainable and therefore must be rejected, ex facie as not maintainable, then, Lord, law, as I understand at least, is that a party is always permitted to take all such steps as are necessary to make the proceeding maintainable. Therefore, it is entirely within my realm, my lord, to then make an application asking your lordship to amend it. I am making this request not because I believe that it is not maintainable today, but because I want to get rid of that objection altogether. That there is no claim as such made before this honorable court, and the claim, my lord, is pending in arbitration. Difficulty is typically because of arbitration and this claim. The difficulty in my humble submission is I can't initiate a Section 9 proceeding in India or any other proceeding in India under the Arbitration Act to secure a particular property which is disputed or otherwise till the determination is made by the tribunal. I can only make a claim before the honorable court with respect to a claim which is really part of a claim under the Admiralty Act. And therefore, if I make a claim under the Admiralty Act, then Lord, I also can't have a duplicate claim of one claim before your lordship, another claim in arbitration, because ultimately this is going to only prove as a security when that arbitral proceedings are
What is
decided.
this amendment?
This, my lord, which is why I'm saying that objection has been taken. Bombay High Court seems to take a view, which, my lord, is that you must also have a maritime claim before the court. But we will not proceed. I'll show you lordship that judgment of the Bombay High Court as well. We will not proceed with the main claim until the arbitration is decided. We will only go into the question of whether the arrest is justified or not. And that is why, my lord, this. Therefore, your lordship may consider, my lord, and allow my application for amendment. They also seem to have made an application to amend their statement of objections by adding a counter claim, which means I have to file my reply to that amendment as well.
File.
The counter claim.
Not yet filed. A
No, no.
counterclaim is not yet taken on record, but I'll, my lords, address first on my friend's argument on amendment. I'll show, my lord, how this is entirely not maintainable. If my friend is done.
You can argue it, of course. You're entitled
No,
to
if
argue.
my friend is completed his argument on the
So far as
amendment.
amendment, my lord, in my respectful submission, I have two submissions to make. One is with or without the amendment, this court has held that the proceedings are maintainable simply as security for an arbitration proceeding, and without going into the question of whether the claim should be there or not. Bombay High Court seems to take a view that the claim should be there. Show me the Bombay High Court judgment. I'll show you lots of that Bombay High Court judgment, Lord, as to how they have devised it.
Alter super.
Which is extracted in this?
Yes.
In the judgment of Judge Sunil Latyata.
This is
Sriram's judgment.
This is Sriram's judgment.
No, that's what the judgment is extracted.
Yes.
May I have a copy? In fact, it's fine.
You also have cited it, I think, no?
No, I have not.
You,
I've cited of the same judge, but of a different judgment.
That is an older one. That is an older judgment, no, which you cited.
Fair enough. I'll have it.
Yes.
Lord, please see page 6, my lord, what the plaintiff's case was. Para 7. It is plaintiff's case that arbitration is an action in personam against so and so. Present action is an action in rem against defendant vessel. Both are maintainable. A full bench of this court in J's Ocean Liner has noted that absent explicit legislation providing that action in rem may be used to obtain and retain security, even though the merits of the dispute are to be determined in arbitration proceedings, and that subject matter of the dispute falls within Admiralty, some procedure which is not prohibited, and that is also not inconsistent with the law we devise, which helps in advancing the cause of justice, in accordance with Article 8. Then judgment in Balco is referred to. Then not D. Just because an action in rem cannot be maintainable for arrest of a ship under Section 9, as held for the full bench, it does not mean that the plaintiff may be rendered remediless because an action in rem in the facts and circumstances of the case, independent of the arbitration, was maintainable. And just because there was an arbitration clause and plaintiff commenced arbitration in London, does not mean plaintiff should be put to a disadvantage. And Article 7 of the Arrest Convention provided for a situation where arbitration proceedings have been commenced. Action in rem was maintainable for security pending arbitration. Admiralty Act does not have a similar provision. At the same time, it does not bar the provisions of the 99 Arrest Convention as held by the Apex Court. Then, Lord, can I request Lord to kindly come to para 20, 21, 20 and 21. I'm sorry, 20. A single judge of the Calcutta High Court. In the case of Alexander's dry run, was faced with a similar situation. I'm sorry, page 22, para 20. A single judge of the Calcutta High Court in the case of Alexander's was faced with a similar situation where plaintiff had commenced arbitration against the charterers for breach of charter party in London, subsequently commenced an action in rem in Calcutta High Court for arrest of a vessel to secure the maritime claim against the charterers under the charter party. Claim in arbitration and the claim in the suit was similar. In para 9 of the judgment, learned judge relied upon English cases, including so and so. adopted the principle of allowing the claimant in an arbitration to secure the claim by issuing a written rem, which was principle based on common law procedure. This also shows that allowing a claimant to arrest the vessel for securing a claim, which is the subject matter of arbitration, is a principle based on common law procedure. Consistent with this common law procedure is the procedure devised by full bench in Golden Progress for retention of security in such cases where arbitration is pending or yet to be commenced and an action in rem is filed to obtain security in respect of a maritime claim. Learned Judge held that there was no abuse of process of the court by instituting the Admiralty suit to secure a claim made in the pending arbitrations already commenced in London. As observed by the Honorable Apex Court in MV Elizabeth, procedure is but a handmaiden of justice, and the cause of justice can never be allowed to be thwarted by any procedural technicalities. All the above shows that the retention of security method devised by the full bench in Golden Progress is only a practical procedural device to do substantial justice to a claimant who is seeking security in respect of a maritime claim which is required to be arbitrated. Then the Constitution bench in Balkowitz considered, I won't trouble your lordships with that. Then note para 32. The Admiralty Act 17 does not affect in any manner the view taken by the full bench in Golden Progress. The Admiralty Act 2017 sets out the jurisdiction of the court to entertain an action in rem in respect to certain identified maritime claims, also the power of the court to arrest the ship to secure such claims, as long as plaintiff is able to satisfy the jurisdiction test set out in the Act and show that it is a maritime claim and the ship is within jurisdiction. Ship is liable to be arrested by exercise of powers conferred by Section 5. Plaintiff is entitled to an order of arrest of the vessel in question. The procedure to be followed by the court for retention of security in the event the parties have agreed to refer the disputes to arbitration, which is either pending or yet to be commenced, is not provided in the statute. Neither was any such procedure provided under the law applicable for arrest of ships prior to the full bench judgment in Golden Progress. Thus, the full bench judgment devised this procedure for retention of security following a successful in rem action, arrest of a ship to secure a maritime claim in proceedings filed in the Admiralty jurisdiction of the High Court. This does not in any manner affect the court's jurisdiction under the law as it stood prior to or under the Admiralty Act 2017. In fact, the Admiralty Act 17 is silent on the procedure following the arrest of a ship. If the disputes are to be arbitrated, then the procedure devised by the full bench is to be applied, as the same is neither inconsistent nor prohibited by the said Act, but on the contrary is in accord with international general principles based on interplay between the arbitration agreement and an in rem action. The full bench in Golden Progress has devised a procedure consistent with Article 7 of 99 Arrest Convention based on sound reasons set out in so and so. Full bench has observed such a procedure would help in advancing the cause of justice and in accord with Article 7 of 99 Arrest Convention. Full bench has drawn upon Article 7 to decide a procedure to do substantial justice to a party who seeks to invoke the in rem jurisdiction of the High Court, where the merits of the claim are to be adjudicated in arbitration proceedings. Section 5, on the other hand, simply confers the power of arrest upon the High Court. It does not set out any procedure to be applied once a vessel is arrested pursuant to exercise of powers by the High Court under Section 5. The Section 5 applies at the stage of arrest. Procedure devised by the full bench in consonance with Article 7 applies after the vessel has been arrested. The two operate in different fields. Following the arrest of a vessel in an action in rem, in the event the disputes are to be arbitrated, whether commenced or yet to be commenced, once the retention of security method as devised by the full bench is adopted, suit is required to be stayed and the security retained for the benefit of the arbitration and the final award that may be passed. Successful claimant who obtains an award would then have to satisfy the High Court that the award is enforceable under the provisions of the Arbitration Act 96. Once the award is declared enforceable, security retained by the High Court pursuant to the action in rem will be made available to the claimant in satisfaction of judgment of the High Court, declaring the award enforceable as a decree of the High Court. This is made clear by the full bench in para 78, where the court refers to recognition of the final decision of the tribunal in accord with the provisions contained in the Arbitration Act. Then Lord Division Bench of the Honorable Gujarat High Court, in the case of Nautical Global, also applied the retention method as divided as the full bench in Golden Progress, consistent with the provisions of Article 7 of the 99 Arrest Convention. Division Bench also observed, suits are required to be kept pending and as such are required to be stayed till competent court or arbitral tribunal decides the disputes or claim between the parties. From this judgment, it is also clear that retention method adopted and the procedure devised by the full bench in Golden Progress has also been applied by the Honorable Gujarat High Court as recently as March 2018. Then 36. Another facet of the use of an action in rem for the purpose of obtaining security for a claim, which is the subject matter of in personam proceedings, turns on the well-settled distinction between in rem and in personam proceedings. This distinction is clearly brought out by three different judgments of this court of three different learned single judges as below. In the case of Crescent Petroleum, a single judge of this court has held and observed with reference to section 35 of the Admiralty Courts Act 1861, that a perusal of the same would clearly show that this court exercises jurisdiction in rem independently of the proceedings which may be taken out against a person's liable in personam. The distinction of an action in rem and an action in personam is valid even today. Learned Judge thereafter referred to the judgment of the English court in the case of so and so and quoted a passage from that case, which appears on page 9 of the judgment. It is of the character of proceedings in rem that they are not alternative to proceedings in personam. They are cumulative. Cause of action in rem does not merge with a judgment in personam, given in respect to a cause of action in personam arising from the same facts. If an action in rem would be still open to a claimant after having recovered a judgment in personam, but without having obtained full monetary satisfaction, then how much more clearly must it be open to him to commence the action in rem, whilst the action in personam is still pending and has not yet proceeded to judgment. Single judge agreed with the above proposition held. I am in respectful agreement with the observations made above, would adopt the same. From the above, it is clear, 38, that commencement of in personam proceedings is no bar to an action in rem. That is because the two sets of proceedings are cumulative and not in the alternative. Arbitration is in personam. Commencement of arbitration, therefore, is no bar to commencement of an action in rem, even though both may arise from the same facts. Thus, the plaintiff, having commenced in personam proceedings by way of arbitration against MEDS, can commence in rem proceedings for arrest of the defendant vessel to obtain security in respect of its maritime claim. Such an in rem action is permissible in law and would not amount to abuse of process.
No, as held by the Bombay High Court or by this court. Now the ship will be arrested or the security that they have furnished. Now the till the arbitral proceedings are concluded. Arbitral proceedings are pending between whom?
Me and respondent number 3.
And the agreement
The claim
between
is also against the ship.
Respondent number 3 and respondent number 1, that is for a period of 6 months.
Yes, ma'am, yes.
That expired long back.
That has that agreement is expired.
Who will he will be waiting for he is not a part of the arbitral proceeding.
He will not be.
He is the person who is
Possibly.
going to pay everything.
Yes, my lord. Now the issue in a maritime claim, my lord, ultimately I should have a claim against a person who is the owner maybe of the ship, or my lord, a person to whom the ship has been given on a charter party. He, according to me, has been given. That is, of course, not a question which you also will have to examine and answer, and possibly there will be some argument on what is the nature.
No, only I am asking you only on the application of this particular judgment.
Yes.
To the facts of the case, where the court said till the arbitral proceedings are decided, let the ship be arrested, and later we will decide basing on whatever it is. Now he is not a party. This owner is not a party to the arbitral proceedings. So how is it going to? What is the effect of it on the first respondent?
My lord, which is why this is only a security. My lord, please consider this, my lord. In a proceeding in rem, ultimately, there are going to be various claims which will come against the ship. One of our claims is also against the ship, insofar as we are concerned, because though, of course, my lord, we were to get it on a time charter, the person who claimed that he had a right with respect to this ship is the one, my lord, who has thereafter come forward and offered it on time charter to us. They claim it was a back-to-back time charter. These are all questions, my lord, which your lordship will have to examine in trial as to whether, my lord, they are liable, not liable. Ultimately, your lordship may conclude at the very end that they are not liable at all. It is possible, my lord, that they are not liable at all. If it does come to that conclusion that they are not liable at all, then the security will be released in their favor, and my lord, that will be the end of the proceedings here. But if I succeed in my arbitration and I am able to show, my lord, that I am entitled to proceed against them and recover this money, then I am entitled to that claim. Ultimately, today the ship has sailed. It is the question of security which is there before the court as to what should be done with the security. Should it be released to them, or should it be held in security until the arbitration proceedings are concluded? It also, your lordships, even if your lordships go ahead with the trial will be limited to the question which they may raise now, not that, oh, there is a time charter which has come to an end. We had a time charter with we were the owners. We had a time charter with respondent number 3. That time charter has come to an end. All those things we'll have to do in the stage of discovery to find out whether there are other time charters, how is the entire structure between the two parties, how are they carrying on business in this particular fashion, and what is the connection between the two. Each of those issues will become issues which your lordship will consider to determine only one question as to where, if I lose in my arbitration in London, that's the end of this case. This case comes to an end almost immediately thereafter. If I succeed and the award is not challenged, then I can come here to enforce the award. At the time of enforcement, my lord will consider the question as to whether it is an award enforceable in terms of section 48 of the Arbitration Act on the grounds that are required there. And then if it is held to be enforceable in India, this security will be available to make good, my lord, the claim that is awarded to me. That, in my humble submission, is the entire process by which this concept of security has emerged. So, of course, my lord, earlier everything happened in Bombay. There were hardly any proceedings. This is the first few proceedings which have come to Karnataka in that sense of how a maritime claim is to be dealt with. Therefore, we my lord, have placed this on the basis that we wanted security for the arbitration proceeding. Now, there are various issues they've raised. I'm not saying my lord, that those issues are not worthy of consideration. But does that by itself result in a situation where they'll be entitled to make a claim that the security be released in their favor, and they not only have the ship set sail, they also can set sail because the second security is released. There is nothing left in this entire proceeding. The entire proceeding will become practically no consequence thereafter. And really, it is that time when the ship is arrested and the ship security is given that your lordships will not really exercise jurisdiction. This is in this context, not I have made this application. So that one technical objection which is raised with respect to the claim for money not having been made is also put to rest. That is the amendment application. No, of course, my learned friend will be entitled to, if your lordships love the application, to file his written statement insofar as the amendment is concerned, if he chooses to do so.
I'm yet to argue on the amendment application.
No, I didn't say you would, but I'm just pointing it out.
Well, let's very briefly. I'll just deal with these judgments and I'll straight show how this, my lord's, amendment application itself can't be granted. My lords, may I trouble my lords first with the Bombay High Court judgment that was tendered across. And I'll then show my lords how this Bombay High Court judgment has been explained by the division bench in this very matter. So first, my lords, alto super, which my friend tendered. And I'll show my lords how it is at complete variance with what, my lords, are the prayers in the facts of the present case. Because this seems to be, my lords, relied even by the Karnataka High Court. So, my lords, let's look at the Bombay High Court judgment, the source, my lord, the source of this, my lord's, fountain. May I invite my lord's attention first to para 3 of the Bombay High Court judgment, my lords, in my lord's alto super, CM offshore ready AS versus alto super. Though not named in the matter, my lords, I had the privilege of appearing in this matter. My lords, I had some idea. Para 3 at page 2. Plaintiff has filed, my lords, a few words I'll lay emphasis on. Admiralty suit for recovery of an amount of 28 so-and-so, which includes charter hire, claim for capital. It's the plaintiff's case that the plaintiff has entered into bareboat charter. Please see, my lords, para 3, there was a Admiralty, a suit was filed and a suit had, my lords, a prayer for decree. My lord, this is para 3. May I invite my lord's attention to para 5, which your lordships will find.
Yes.
Please see what was the argument before, my lords, the Bombay High Court. According to the plaintiff learned that MEDS had purchased defendant vessel alto super. Plaintiff relied upon a CWeb report which confirms that MEDS was the owner stroke charterer of the of alto super. Therefore, the plaintiff had filed Admiralty suit in this court for identical claim which was made in the arbitration proceedings. The plaintiff obtained an order of arrest. According to the plaintiff, notwithstanding the pendency of the arbitration proceedings, an award that may be passed in London, plaintiff is entitled to file a suit seeking arrest of the defendant vessel as security for the plaintiff's claim in the suit, not the claim in the arbitration. For the plaintiffs, you have to seek security for your claim in the suit, right? According to the plaintiff, it is also entitled to seek, let's please see the next words, seek decree against the defendant vessel and obtain security for its claim in the suit. Alternative stand is also taken that the defendant vessel can be retained as security for arbitration proceedings commenced in London. Obviously, your lordships are aware. I'll show, my lords, in a detailed discussion in this. It is not as if you file a suit, claim a decree, arrest a vessel, for which, of course, against when you don't have a claim against the owner, but you and then say, sorry, all my disputes will be adjudicated in arbitration, not in the present suit. It defeats the purpose of filing a suit and claiming a decree, assuming, my lords, a decree has been sought. Also, my lords, law has been clear on this even in arbitration, that merely filing a suit does not, and with an arbitration clause does not mean that now you seek an interim order and the rest everything to be adjudicated in arbitration. Someone will have to formally file, if it's a domestic arbitration, an application under section 8, or if it's an international commercial application, and application under section 45. It is only when the court looks at an 8 or a 45 will the matter be referred to arbitration. Until then, a suit proceeds like an ordinary suit. Nothing special in Admiralty jurisdiction, whether in Bombay, Gujarat, Orissa, my lords, or even Calcutta, or even Madras for that matter. At least, my lords, jurisdiction that I had, my lords, had the privilege of appearing. But as my lords are seeing, since this judgment was cited for, my lords, the court's reference, important to see, in all these judgments that are cited, a decree was sought, and ultimately the argument before the court was that ultimately the issue, you seek a decree against the vessel and adjudication of that decree in the suit. So that's, my lords, para 5. May I also invite my lord's attention to para 15. This is, my lords, the full bench judgment, which was also quoted, my lords, in this court's judgment, in the Karnataka High Court's judgment. The full, it's at page 19.
Page 19.
1919. It's on the top of the page.
Yes.
And your lordships have seen, my lord, the same learned single judge, my lords, who had decided the earlier judgments that have tendered, had distinguished the full bench judgment, saying that even in the full bench judgment, ultimately a decree was sought. But I had tendered those two judgments on the last occasion. Please see, my lords, para 15. Full bench in Golden Progress had held in para 78 an application for section 9 is not maintainable for arrest of the vessel for obtaining security of an award that may be made in arbitration proceedings. The opinion of the full bench that section 9(2)(b) of the Arbitration Act cannot be construed so as to read into it in rem jurisdiction. According to the full bench, the said provisions did not cover the arresting of the ship or keeping a ship under arrest in exercise of the court's jurisdiction in rem at all. The court said that in what is provided in 9(2)(b) is securing the amount in dispute in arbitration by way of an interim measure which does not include the arrest of ship, and the provisions does not refer to jurisdiction to issue a warrant of arrest. The full bench did not make any distinction between a case where arbitration has already been commenced before an action in rem, and the arbitration is yet to become.
What is the ratio laid down in this judgment?
So the ratio laid down in this judgment is mere commencement of in personam proceedings, which are arbitration between two parties, will not prohibit the Admiralty Court from granting the order of arrest. Now, there are two aspects which is also clarified, which I will demonstrate, provided, and the Bombay High Court says, and my lords, it's not very different. The Karnataka Court really does not decide this issue. But what is important is ultimately that you have to seek a decree, and it has to be a suit. I will demonstrate, my lords, even based the Karnataka High Court rules. Civil petitions is not, my lords, is not a suit. My lord, there is no procedure, my lords, for filing written statements, issues being framed, evidence being laid, and my lords, ultimately trial being conducted in a civil petition. So I will demonstrate, my lords, on reading of the rules as well. But the point is that it has to be an Admiralty suit. And my lords, even I heard my friend argue, all these are issues to be decided in trial. Which trial will be decided? I mean, in which trial can these issues be decided? I am not a party in the arbitration proceedings. Therefore, I certainly can't be heard at any point in time. And I will demonstrate, my lords, this argument is, if accepted, will turn, my lords, the Admiralty Act on its head. We have seen, my lords, section 5 of the Admiralty Courts Act of 2017, which says for an order of arrest to be granted, and my lords, the judgments which say, or the order of arrest to be sustained, it is important that you meet the test of section 5. Section 5 contemplates that you either have a claim against the owner or the demised charterer. Now, plaintiff has not produced any document to show that its claim, in fact, they've been pretty categoric on this point, that their claim is against defendant number 3, who admittedly is the time charterer, and certainly not the owner. I have shown, my lords, attempts made to, my lords, make false statements in the plaint. At one stage, they show who the owner is, but ultimately they try to then say that the charterer is the owner. My lords, this was argued on the last occasion. I will demonstrate that, my lords, unless test of section 5 is not met, there is no question either for the court to grant an arrest or sustain an arrest, or let the arrest continue. An arrest, my lords, in this case, as my lords in most of the cases, was obtained ex parte. So therefore, my lords, the owners were not before the court to demonstrate or to point out that on a plain reading of the plain, you do not mean.
According to you, the ship can be arrested, though there is no claim to be decided by this court, provided the relief that is sought as seeking the whatever monetary claim.
Decree.
Decree what they are seeking. No, they filed an amendment petition.
I will answer that. The amendment petition is ultimately, and I'll point that out. Amendment petition is to amend the civil petition. But this is not a suit. I don't think.
I think my learned friend may not be aware, my lord, but here we don't have Admiralty rules yet made, and that is why it is filed as a civil petition.
I'm sorry,
it's not like we have an option.
I'm sorry, my
lord.
lord.
We have chosen some jurisdiction which doesn't exist. I've been filing and appearing in civil petitions all this time. The registry says I don't know how to put it under any other jurisdiction.
I don't. If there is no procedure can be created tomorrow, my lords. Writ petitions will be filed and said, sorry, there is no procedure. I will file a writ petition to arrest. That's not really an answer. If there is no procedure, there is no procedure. You arrest in a jurisdiction that has a procedure where the ship goes. It's not as if the ship remains only in one jurisdiction. It keeps on traveling. My lord, there are several times that one vessel, my lords, it moves from my lord Singapore.
So the CP is filed.
Yes.
Under which provision?
Under the Admiralty Act. Under the Admiralty Act itself. I'll tell you also what happened. Earlier, my lord, for arbitration petitions, for enforcement of foreign awards, there was no classification there. So it was filed as a civil petition. Thereafter, my lord, rules were made by the High Court, and thereafter it was classified as arbitration petition enforcement.
Karnataka High Court.
No, rules are not there. As a matter of fact, I'm told, my lord, a committee is constituted to make rules.
So now all these petitions are filed in the form of a CP.
Everything is filed in the form of CP, not the first one. The last one which your lordship saw, which was taken to the division bench and then which has gone to Supreme Court, is also a civil petition. So my learned friend making much of as if we are trying to find a new jurisdiction.
I don't. My friend, my lords, literally jumped before I could complete. My lord, if this is to be treated like a suit, then my lords, even as per the Karnataka, my lords. May I please complete?
No, but you can't make a statement.
I did not interject, my friend. We don't get subdued by all of this, my lord, these constant interjections. My lord, the fact of the matter is, if this is to be treated like a suit, because my friend says that there is no suit, and just look at the, my lords, the flip side of the coin. My lords, a suit, though there is no suit, my lords, a CP is filed. Attempts made, my lords, to evade payment of court fees, because my lords, in Karnataka, my lords, the court fees paid on my lords for any suit is on ad valorem basis. I'll demonstrate all of this. But all of this was attempted to be done in different parts of the world. It was attempted to be done in Odisha, because my lords, because Odisha High Court, my lords, like Karnataka, has ad valorem court fees. So people used to go file suits in the civil court with a suit for injunction, which of course all these practices were deprecated. And my lords, we are now looking at, my lords, we are now governed, my lord. This will be, my lords, under 2(1)(c) of the Commercial Courts Act, and my lords, a commercial dispute. So my lords, governed by the Commercial Courts Act. The fact of the matter is, if this is, my lords, filed, if this my lords, CP is to be treated as a suit for all practical purposes, with no trappings of, my lords, my friend, my lords, points out the difficulties that the plaintiff faces without factoring into, my lords, the difficulties that the defendant faces. No procedure for filing written statement. No procedure for framing of issues, evidence to be laid, my lords, trial to be conducted, my lords, in a civil court. If I'll show, my lords, the Karnataka High Court rules. This is framed under Chapter 7. A CP, you only file objections to the CP. As who better than your lordships would know this? There is no system of filing a written statement. So, my lord, a person cannot come and say, I have no recourse. There is no procedure set in place. So therefore, I will now do what I think, my lord, is available to me, irrespective whether it has the backings of law or not. And merely because, my lords, it has been done in the past where nobody has raised an objection, does not mean that, my lord, the court has granted its imprimatur. This is not a case. My friend will.
I'm just standing. I'm not making submissions to you. I'm making submissions to the court. So please don't tell me what I have to do now. Please see the order in the OSA.
I'm facing with the interjections. Obviously, I'm bound to raise.
Please see the order in the OSA, my lord. This question was answered. The division bench judgment. My learned friend is saying all this. This question was raised and answered. This whole commercial court jurisdiction, all of that.
If we keep on doing this, my lords, we'll never end up concluding any hearing, because for every point my friend gets up and, my lords, is now interjecting.
But you're saying something which is already answered by the division
I
bench.
will deal with it. It's not as if I'm not dealing. You've cited judgments. Let me deal with those judgments.
Lord, please see, my lord, para 23.
Typically, when, my lord, someone does not want, my lords, the hearing to, my lords, proceed, my lord, we are faced with the interjections.
Keep his
my friend,
allegations to himself.
I will, provided my friend allows me to conclude.
Why should we spend time on this?
Up to para 23
of, my lords,
the division bench judgment.
Yes, my lords. Yes, my lords, I have the division bench.
Please read that.
My lords want me to see para 23.
3.
Yes, ma'am. Lordship may just give me. Yes, my lords, para 23, though the learned counsel, appellate's counsel contended the claim constitutes a commercial dispute. Therefore, the claim lies before the commercial court in form of a suit ousting the jurisdiction of the High Court. He could not demonstrate how the jurisdiction of the High Court is barred under Section 3. My lord, I'm making a slightly different point. It is not my contention that, my lords, as is contended here, that it is outside, it can't be entertained by the High Court. My contention is slightly different. A civil petition is not a suit. I have heard my friend argue, my lords, at least, my lords, on 3 occasions, that this issue will have to be decided in trial. All that I'm suggesting is that civil petition does not contemplate any trials. There is no procedure. And at least, if I may continue reading after this, please see what was the issue. Reading the above provision shows that the High Court alone has exclusive jurisdiction to deal with maritime claim covered under Section 4 and 5. Though the definition of commercial disputes under Section 21C of the Commercial Codes Act covers issues relating to Admiralty law, there is nothing barring the jurisdiction of the High Court on the issue relating to arrest of the vessel under Section 5. I can't, my lords, even on the last occasion, my friend wasn't here. But the fact of the matter is, it was not my contention that the High Court can't hear the petition. Of course, my lords, Section 3 of the Admiralty Act makes it very clear that it is only the 8 High Courts. The Admiralty courts have been, jurisdiction has been conferred only, my lords, on 8 High Courts. And that is why, my lords, how only 8 High Courts have been conferred with this jurisdiction. Not my argument that this can't be heard by the High Court. My argument is slightly different. If my friend's argument is to be accepted, my lord, unless, my lord, the procedure contemplates claiming of a decree in a civil petition, I don't think we can really convert a petition into a suit. That was my contention. I don't think that is an issue, my lords, which is considered by the division bench and which is, my lords, answered in the division bench. The argument here is that there has to be a commercial division, which, my lords, I don't think I'm raising that issue. I said that this will have to be in the commercial. It is under 21C. It has to be a commercial dispute. But since it is, I understand a commercial division not being set up, and there is some suit. It happens, my lords, quite often in the Gujarat High Court. The Gujarat High Court, my lords, there is no commercial division separately, my lords, constituted. So it is filed in Admiralty jurisdiction, but with all trappings of the Commercial Codes Act being applied. My argument that I've raised here is, my lords, on a completely different point. That how does one party conduct a trial and seek a decree in a civil petition? But that was one of the grounds for which, my lords, I was opposing. But, my lord, that argument apart, I will demonstrate, my lords, on reading of the judgment that.
Continue after now.
Yes, my lords.
Disposed of. When is it that we incorporate?
ಇನ್ಕಾರ್ಪೊರೇಟ್ ಮಾಡ್ಕೋಬೇಕು ಅದೇ ಏನು ಬಿಸ್ನೆಸ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇರ್ತಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ 6624 ಡಿಸ್ಮಿಸ್ ಈ ಇನ್ಕಾರ್ಪೊರೇಟ್
ಇದನ್ನು ಡಿಸ್ಮಿಸ್ ಅಂತ ಕಳಿಸಿಲ್ಲ
ಇದನ್ನು ಡಿಸ್ಮಿಸ್ ಆಲ್ರೆಡಿ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂದ್ರೆ ಇವಾಗ ಮೇಡಮ್ ಏನು
ಮೇಡಮ್ ಇದೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ 2:30ಗೆ.
ನಾನು ಕೊಡ್ತಾಕ್ತೀನಿ ಅಷ್ಟೇ. ಏನೋ ತಗೊಂಡೋಗಿ ಕೊಟ್ಟೆ. ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ನೀವ್ ಹೇಳಿರೋದೆಲ್ಲ. CH-25.
Yes.
My lords, what I have, my lords, a little pondering over during the lunch. My lords, what I'll do is, my lords, I'll just in bullet points indicate, my lords, what really is my objection to this, and I'll deal with my friend's arguments also on those points. Because, my lord, ultimately, as my friend argued in his opening, that this deals with, or rather, this is an attempt to deal with one of the several points that I have raised during the course of my argument when I argued I1. So let me, my lords, just put it in bullet forms. Whether let me categorize my friend's arguments on two broad headings. The first heading was that, frankly, the argument started by saying decree is not really required, and since decree is not really required, for which two judgments were relied upon. One was, of course, the Karnataka High Court judgment in Mech Petroleum versus my lords Global Emerald, single and division bench, and second was, my lords, the single judge.
I'm so sorry. I've only argued the application for amendment. I just want to clarify. I just argued the application amendment, answered your lordship's queries. I've not argued the rest of the applications.
No, I follow that.
I'm just pointing it out so that we
Yes,
don't
yes.
end up arguing.
I understand my friend's argument only in that context. There's no difficulty. So, my lords, his argument was on relying on these two judgments, decree is not really necessary in that sense. And that's how, my lords, those two judgments. In my respectful submissions, I'll complete this in bullet form so that I'm done with this portion. Both all the three judgments relied upon, be it Mech Petroleum single, Mech Petroleum division bench, or Altis Uber of Bombay. All these three judgments in paragraph 2 of the Karnataka High Court judgment and paragraph 3 of the Bombay High Court judgment was a case where decree was sought. So in my respectful submission, with the greatest of respect, they are completely different. Completely different factual scenarios. I don't think that judgment can assist, because factually a decree was sought, factually a decree not sought in the present case. So that was that. The second point that was sought to be argued was on that the trial, if any, was to be the trial in arbitration and not the trial in the present proceedings. May I just show, my lord, a straight provision of the Admiralty Act to first show that, my lord, this, I'll come to case law later. Let me satisfy, my lords, on the statute itself. May I invite my lord's attention to section 4.
Before going into all that, the judgment that they have relied on,
Yes,
even the single judge of this court also,
My lord,
Justice Sriram, if you look at paragraph number
Altis Uber.
para 32, straight
My
and
lord,
come to that.
please. May I read, my lords? The Admiralty Act does not in any effect, it does not affect in any manner the view taken by the full bench. The Admiralty Act 2017 sets out the jurisdiction to the court to entertain an action in rem in respect of certain identified maritime claims and the powers of the court to arrest a ship to secure such claims. As long as the plaintiff is able to satisfy, this is very important, the jurisdictional test set out in the act and show that it has a maritime claim and the ship is within the jurisdiction and the ship is liable to be arrested in exercise of powers under section 5 of the Admiralty Act, the plaintiff is entitled to an order of arrest of the vessel in question. The procedure to be followed by the court for retention of security in the event parties have agreed to refer the dispute to arbitration, which is either pending or yet to be commenced, is not provided in the statute. Neither any such procedure provided under the law applicable for arrest of the ships prior to the full bench judgment. Thus, full bench judgment devised this procedure for retention of security following a successful in rem action and arrest of the ship to secure the maritime claim in proceedings filed in the Admiralty jurisdiction. This does not in any manner affect the court's jurisdiction and under the law as is understood prior to or under the Admiralty Act of 2017. In fact, the Admiralty Act of 2017 is silent on the procedure following arrest of the ship. If the disputes are to be arbitrated, then the procedure devised by the full bench is to be applied, as the same is neither inconsistent nor not prohibited by the Act, but on the contrary, it is in accordance with international general principles based on interplay between the arbitration agreement and an action in rem. So, my lords, two aspects, as my lords have observed rightly in my respectful submissions, and I'll show my lords how this has been clarified subsequently by the division bench.
No,
But
whether the amendment is permissible or not is one issue.
Is one
In the
issue.
light of this judgment, whether such an amendment needs to be incorporated or allowed or necessary, even without that amendment also, still they can maintain this application is another issue.
There are three
Now,
issues.
when this, without going into the amendment, what they sought, whether it is permissible or not, assuming that there is no amendment, they have not sought for any
Decree.
relief from this court,
My lord,
and they've only sought this particular relief of arresting the ship.
my lord.
In that case, what do you say? What this judgment is saying?
Yes, my lords, this judgment talks about, my lords, two aspects. My lords, one, it talks about the test that is required to be satisfied, that your lordships have noted in terms of section 5.
And
That
there
will
is
have,
there is a categorical finding.
yes,
I'll just point out.
yes. So here, the full bench has devised a procedure for retention of security. Is that what the court, my
No,
lords?
1 minute. Para 38.
I'm sorry, my lords.
Para 38.
38. From the above, it is clear that commencement of in personam proceedings is no bar to an action in rem. This is because two sets of proceedings are cumulative and not in the alternative. Arbitration is in personam. Commencement of arbitration, therefore, is no bar to commencement of an action in rem, even though both may arise from the same facts. Thus, the court has commenced in personam proceedings by, thus the plaintiff having commenced in personam proceedings by way of arbitration against MEDS can commence in rem proceedings against the arrest of the defendant vessel to obtain security in the respect of the maritime claim, and such an in rem action is permissible in law and would not amount to abuse of process. My lord, this what my lords, what the learned single judge says is that merely because you have invoked arbitration, inter parties.
Then please come to para 40. Read para 40 also.
My lord, para 40. It is clear from the above quoted portions of MV Smart and which relies upon paras 55, 56, and 58 of the MV Elizabeth. It is only after the owner enters, this is very important, owner enters appearance, submits to the jurisdiction, furnishes security, that the action in rem gets converted into an action in personam. It is at this stage, before proceeding further with the action in rem, the court will adopt the procedure devised by the full bench until such time as the owner has entered appearance and submitted to the jurisdiction of the court and furnished security. The action in rem remains an action in rem, and the vessel is available to the plaintiff as a security in respect of its maritime claim, which is subject matter of in personam proceedings by way of arbitration against the owner or the party liable in personam. Furnishing security is also an essential form of the action in rem to be converted into an action in personam. Until such time the security is furnished, the vessel remains.
You can now come to para 49.
49.
48, you can read from 48.
When it was submitted by the applicant, it is open for the plaintiff to commence an action in rem to obtain security in respect of a maritime claim in the event the plaintiff has not commenced arbitration. What this means is that if the plaintiff wants to secure his maritime claim, he has to first wait until he is able to track and arrest the vessel before he commences arbitration. If he commences arbitration first, then he'll not be entitled to file an action in rem for arrest of the vessel to secure his maritime claim. Such a proposition of law is not supported by any judgment, nor does it advance the cause of justice, but on the contrary would be regressive in operation in as much as it would put a party who has agreed to refer disputes to arbitration at a massive disadvantage, because such a party would lose his right in rem to arrest the ship to secure his maritime claim if he commences arbitration before filing an action in rem. As stated earlier, a right in rem is a valuable right, and a party cannot be deprived of the same if he has invoked arbitration unless there is an express prohibition to this effect in law. 49. Golden Progress held that an action in rem for arrest of a ship to secure a maritime claim can be filed notwithstanding the disputes are required to be arbitrated, irrespective whether the arbitration is pending or is yet to be commenced. In fact, Article 2(3) of the 1999 Convention states so and so. This makes it clear that a ship may be arrested even when maritime claim is to be arbitrated. The words "is to be arbitrated" is very neutral expression and would mean that the dispute is to be ultimately decided in arbitration and not in court, irrespective whether the arbitration is pending or yet to be commenced. In this context, reference may be made to the judgment of the English court in Jaimatsya, where the court was called upon to interpret provisions of section 26.
But you can skip, come to para 50.
Yes. The above reasoning equally applies when an action in rem for arrest for the purposes of obtaining security in a case where arbitration proceedings have already been commenced, applying the procedure devised by the full bench in MVE progress, the matter not whether the arbitration has been invoked or is yet to be invoked.
Also, you can continue.
I'm sorry, my lords. 51.
Yes.
Any other interpretation would not only defeat the interest of justice, but would be contrary to the avowed objects of the court and Parliament to promote alternative dispute resolution by way of arbitration or mediation. If a party, this is very important, if a party agrees to arbitration, it cannot be that he is to be deprived of his right to rem to obtain security in respect of maritime claim. Just as a party who agrees to arbitration with the seat of arbitration outside India can apply for interim measures to the court under section 9 of the Arbitration Act, irrespective of the fact that the arbitration may have already been invoked before such an application is made. So also a party who should not be deprived of his right in rem to invoke Admiralty jurisdiction and obtain arrest of a ship to secure his maritime claim, even if arbitration has already been invoked. As noted earlier, after the 2015 amendment to under section 9 read with 2 of the Arbitration Act, a party can approach to this court securing the amount in dispute in arbitration, even in arbitration. Just because the party cannot maintain an admiralty action under section 9, can a party be deprived of a chance to secure its claim in arbitration? In Golden Progress, the full bench has held that the court has devised a procedure to permit a party who has agreed to submit disputes to arbitration. As noted earlier, there is no explicit legislation barring such security.
Yes.
My lords, two aspects on this. Having read this judgment, my lord,
yes,
the issue involved in this judgment was that whether existence of an arbitration agreement by itself would create a bar against a plaintiff from moving an admiralty court seeking an order of arrest. That is one. Second, if the arrest has been granted, thereafter the owner has entered appearance, furnished security, and submitted himself to the jurisdiction, it gets converted into an action in person. That's the second limb of the argument. The third limb of the argument is, which it contemplates, is that in case the dispute, now once security is furnished, disputes have been thereafter by the parties have agreed to be referred to arbitration. In that case, or there is a pending arbitration, in that case, what aspects have to be, what would be the consequences? This judgment, my lords, and I'll show it has been better clarified thereafter, but this judgment does not deal with three aspects which are involved in the facts of our case. It does not deal with an aspect where a vessel has been arrested belonging to an owner with whom there is no arbitration involved. The arbitration dispute, and my lords, I will take the court through the plaint again if need be. Their entire claim is against defendant number 3.
No, you heard the argument of the learned senior counsel saying that all these issues, whether there is any contract or agreement between you and them,
I'm going
to
say, my lord, this issue, what my friend says is tribal. I'm going to show direct judgment on this point, where the court says, and of course, but that's on my argument on section 1, in my I1. As my friend argued, this is only for the purposes of amendment that I was opposing, but I will show a direct judgment where, in terms of a breach of a charter party, can you, for a charter party where the dispute was with the charterer, can you arrest an owner's vessel? And whether, no, my lord, it's something new which I will be, my lord, which I will cite. It actually goes on to say that there is nothing tribal about it. In the facts of this case, when they admit that their privity is with defendant number 3, and not with the owner, what is to be tried? Once there is an admission and that admission is categoric, and they say this, my lords, not just in the plaint, in their response to the IAs, to the interim application preferred, even to their, my lords, to their amendment, in their amendment application, they are very categoric. They say that my claim is against defendant number 3. So whether that meets the test of section 5 is a separate argument, which I have already advanced. I will, my lords, satisfy the court on the to the hilt on that basis that it cannot be. In the Karnataka High Court judgments, I will show it. The judgments read their claim was against the owner. Their claim was not against the charterer. At this stage, the charterer comes and says, sorry, but the owner comes and says your claim was against the charterer. The court says whether the claim was against the charterer.
It is an undisputed fact that their claim
Is against the
that
charterer.
The contract is between the charterer and
that's it.
And the party.
And
what is the judgment?
I will. May I complete my arguments on the?
You show that.
Yes. Please give me MV Umka. Even, my lord, says by the time they pull out the judgment, even the section is very clear. The section says you can arrest a vessel provided you have a maritime claim against the owner or against the demised charterer. Documents, the only document on record which shows the type of charter party is a time charterer, not a demised charterer. They have not relied upon any document to show that anything which would remotely hint that there is a demised charter. We have produced a document which shows that the defendant number 3 is a time charterer. Therefore, the test under section 5, and what is prima facie case? I have relied upon the Gujarat High Court single judge, which really considers the law threadbare and says that reason to believe means there has to be some material on the basis on which the court comes to a conclusion that yes, prima facie, I can send you to trial. Observing. We have given it. Lords, print is coming. I believe, my lords, there was some mishap from our side. But I will, my lords, demonstrate with that judgment, my lord. That is, in my respectful submission, a complete answer to this issue. In any event, my lords, the Gujarat High Court judgment also, and even the Karnataka High Court judgment, my lords, which was that was a case which Mech Petroleum was a case, just to, my lords, indicate, was a case where bunkers were supplied. Bunkers are basically fuel to the vessel, were supplied to the vessel. A requisition was made by the master of the vessel saying, please deliver me, I need fuel. The master endorses the bunker delivery note. Now the master, my lords, is generally an employee of the owner of the vessel. As against the judgments that I had cited, where there was a stamp affixed saying that this delivery was at the instance of the charterer, the court comes to a conclusion whether the requisition was made by the owner or a charterer is a tribal issue. That, my lords, is a separate issue altogether, because delivery was made to the vessel has received the goods, the master has endorsed the bunker delivery note, and the bunker delivery note constitutes, my lords, in that sense, a contract read with the requisition. So there was a contract with the involvement of the owner, in which case it is all right for a court to say, I want to send you to trial in facts and circumstances of the case. As against this, look at the facts of our case. The facts of our case indicates that the petitioner has a contract with respondent number 3. Admittedly, no involvement of the owner. The only two people who are a party to the contract are the petitioner and respondent number 3. They say that the breach is committed by respondent number 3. The owner has no role in this to play, except giving the vessel to a charterer who has then down the line chartered it to respondent number 3. But that by itself, and in fact the charter party makes it clear, it stipulates, I will, my lords, show the charter party again. Now the new charter party, which was, my lords, filed in form of an additional affidavit, which goes on to show that it says this is not a demise. This is a term in the charter party which says this is not a demise. If it is not a demise charter and the plaintiff's claim is only against the charterer, then, my lord, there is the test of section 5 prima facie cannot be said to have been made. But that is, my lords, the in so far as, my lords, the argument in, my lords, I1. My lord, there is of course there is another I preferred, which says and which invokes, my lords, order 2025 of the CPC, which says you have granted an order of arrest against the plaintiff. Alternative, assuming the worst case scenario, that the court is against me on this point. Then with a foreign plaintiff, it is imperative, and my lords, order 25 is mandatory, and I'll rely upon a direct Bombay High Court judgment on this issue in an Admiralty proceeding. Then the petitioner must secure for cost that are likely to be incurred in the present proceedings. An application has been made. We've seen their reply. It is, my lords, a direct judgment on this proposition. In fact, my lords, apart from counter security, which can be done in 11.3 under order 25, it is mandatory because the petitioner is a foreign party having no assets in India. So assuming tomorrow the arrest is found to be wrongful, there is no recourse for the petition, for in fact the vessel owner to then recover that amount. He has to then institute a suit somewhere, wait for the proceedings. Whereas it can't be, there has to be a even, my lords, aspect when the petitioner comes, he says, I come, ex parte order of arrest, liability of some other party, I arrest your vessel, I am entitled to do so. Please see, my lords, what is their case in the petition. Their case in the petition is, and I'm at the cost of repetition, I say this, that they claim a decree against defendant number 3 only at the highest. Their entire fault that they have, my lords, averred all throughout in their petition is that liabilities of defendant number 3, not once. And in that, of course, there are, my lords, false statements that have been made all across. Separation issue apart, they know who the owner is, but they have sought to, because their own document annexed to the petition shows who the owner is. But then at various points in the petition, they start averring try to, my lords, rope in different parties to say, sorry, he's the owner, he's the owner. Their contention is belied by their own document. May I just, my lords, quickly, my lords, take my lords through I1 for a brief minute. In fact, in their petition for a minute. My lords, in their petition at page 61,
both belong to the applicant.
correct. If my lord sees page 61, this is, my lords, a document annexed to their petition.
Yes.
If my lord sees, my lords, at 61, your lordships must have marked the name of the ship, CS Flourish. This is respondent number 1 vessel. Please come to the next page, page 62. Please see who the registered owner of the vessel is.
I think you pointed out on the last.
That's correct.
petition, I
Now,
remember.
I'm just going to show, my lords, how, my lords, this order of arrest has been obtained in a manner which is completely by being completely untruthful to the court, by suppressing the fact, and, my lords, on completely not meeting the test of section 5. That is why, my lords, this interlocutory application. I can understand, it's one thing to say, I understand the argument of tribal issue.
What are all the IAs filed by you?
I'm sorry, my lords.
What are all the IAs that are pending, which are filed by you?
My lords, the IAs that have been filed, IA1 is to, my lords, vacate the order of arrest and refund security. Then, my lords, there is, sorry, I2 has been filed for the purposes of seeking counter security. My lords, should the arrest be held to be, if the arrest is to be held wrongful, then the damages that I have suffered be secured. I number 3, which is, my lords, is for amendment, is to amend the objections to basically, my lords, incorporate a counter claim. That was, my lords, one of the
On what is your counter claim?
for what, for the wrongful arrest that has taken place, the losses that I have, my lord, suffered, the vessel owner has suffered. Is
So in a CP, under which provision you?
no,
file a
yes,
counter
correct,
claim?
my lord. That argument cuts my argument. That I must concede as an officer of your lordship's court.
Next.
Because, my lords, this application, assuming this is to be treated as a suit, and if I file this application, and if this application is to be allowed, then it would be, my lords, under order, my lords, under order 6 rule 8A, which then for that counterclaim we are liable to pay, my lords, court fees. Then, my lords, the next, but the most important I is IA number 4. This is that is for an application under order 25 rule 1 of CPC. That is directing the plaintiff, because he is a foreign plaintiff, and my lords, on a plain reading of 25 as well as case law suggests that when the plaintiff or a petitioner is a foreign party, then the court does not have an option but to order, my lords, counter security, security for cost.
That is I number 2.
That's I number 4. 4 is different. But first is, my lords, 25 is security for cost. Should the court, my lords, come to a conclusion that there is tribal issue and refuse to vacate and set me to trial, in which case the cost, my lords, have to be secured by the petitioners. That is by giving of an estimate. That, my lords, estimates have been given, to which an objection has been filed. So, my lords, if I, assuming I should not, we are sanguine that, my lords, we should succeed in I1, in which case, my lords, the court may not order I4. But should we fail in I1, then I4, my lords, in my respectful submissions, will automatically trigger directing the petitioner to secure costs involved in the proceedings. My lord, these are essentially the 4 I's that have been, my lords, filed.
And their IA for amendment is?
I presume it must be 5 because we have been given an unnumbered, unaffirmed copy.
It's not numbered.
I don't think it's numbered. I don't think it's numbered, but it's IA number 5.
We argued something which was not on board and which is not numbered.
But we handed it over.
But this is something not we are giving in a writ petition.
Usually, my lord, but what happens in our civil courts, my lord, is that all applications are filed across the board. Not that it should be done this way, but it should have been possibly filed and then brought up before your lordships. We'll have it done. We'll ensure it's done.
No, it is like this. IA1 is filed to vacate the said order, irrespective of looking at your amendment. Basing on your argument, court has granted an order. That is the first application to be heard. And in case if you're not hearing that application, definitely, as rightly said by him, IA4 has to be heard, because on your claim, somebody is made to
give security
of 100, how many crores? 1 crore.
15 crores.
15 crores. So, in case if you are unsuccessful before the court, so how are you going to?
That is the provision for security for cost, my lord, which actually provides that if a particular plaintiff is a foreigner, then he's required, and he does not have any assets within the jurisdiction of the court, must provide security. Now, of course, my learned friend must make a choice as to whether he's arguing this is a civil petition or as a original proceeding in a court which is going to be tried as a suit. My learned friend can take that choice first.
The section is numbering it as a CP, all the matters.
My lord, please.
So we have to know the rules that are applicable to the CP definitely can't be applied to this, because it is like they are raising, as you say, it has to be a decree. They seek a decree, an IA for injunction, or for an application for arrest, and all other things will follow, whether they have asked in this petition or not. So forget that argument, whether a CP is maintainable. So then coming to this, you want to argue on IA number 1 or IA number 4? No, my lords, IA number 4 is in alternative to IA number 1. I must make that very clear. The two are not maintainable together. Now, without going into the trial and other things will come later. but basing on the undisputed facts.
Yes.
As per your own amendments, your own documents, it is your case that your agreement is with the, that's
There's no doubt.
undisputed
There's
third.
no doubt about that.
So now he is placing before the court about the test of section 5 and about the judgment that what is a time charter and the other is
Demise charter.
demise charter. Your case is that it is a time charter.
This at
And
least
like, it is not a demise charter. Unless until it's a demise charter, question of arresting the ship does not arise, is what is
Yes,
contingent as per the judgment.
this is like, if I may answer the question, this is like saying a license versus a lease.
That's exactly one of what I argued when I opened up.
So if I thought my learned friend was,
We agree on some things.
no, I thought I don't agree a lot with one thing. My learned friend was very angry with me whenever I interrupted. but when it suits him, he interrupts. So
I did apologize to my friend outside.
it's okay. I
which
don't
which
say.
we did.
It really does not matter. What we do in court is for the case. It's really of no concern. Correct. That question, Lord, as to whether it is a license or a lease, has always been a matter of trial. To determine the question as to whether a particular document, though maybe titled as a license agreement, your lordship will always consider it after examining the document to see as to whether it is a lease.
No, when you yourself say.
We've said so. We've said he's a deponent owner. We've said so. It's a
Charter,
deponent
time
owner.
charter.
Whether it
And
will
for
be
the-
allowed or not will be a question which we'll have to examine.
Admitted facts, we don't have to prove.
No, we don't have to. Admitted facts, we don't have to prove. But you never said anything about whether it's a demise charter or not. We've not said it is not a demise.
Demise charter, it will not be a demise charter.
Well, it could be.
I'm
It could
sure
be. Why
my
can't it be?
friend.
A time charter, there's nothing, my lord, your lordship will see the Admiralty Act does not deal with the concept of a time charter. Please see the Admiralty Act. Your lordship may kindly see section 5.
Yes.
This is one of, my lord, if I may say so, an exception to a owner. So an owner may have chartered it, but he'll still have to suffer the consequences if there's a charter. Arrest of a vessel in rem. The High Court may order arrest of any vessel which is within its jurisdiction for the purpose of providing security against a maritime claim, which is the subject of an admiralty proceeding, where the court has reason to believe that A, the person who owned the vessel at the time when the maritime claim arose is liable for the claim and is the owner of the vessel when the arrest is effected.
So what is meant by this provision?
Lord, that doesn't arise because the claim, my lord, is not against the owner of the vessel. That I don't think.
He will not apply.
We are not. A won't apply.
We'll go to B.
We'll come to B. The demise charter of the vessel at the time when the maritime claim arose is liable for the claim, and the demise charter or the owner of the vessel when the arrest is effected. I'll show one judgment after this. Or the claim is based on a mortgage or charge of the similar nature of the vessel, or the claim relates to the ownership or possession of the vessel, or the claim is against the owner, demise charterer, manager, or operator of the vessel, and is secured by a maritime lien as provided in section 9. There are these 4 events, my lord, which could occur, and even if I come under any one of those, I will still be ultimately entitled to arrest the ship. Now, the question as to whether he is a demise charterer, whether it is a demise of the ship in favor of someone, is, my lord, in my humble submission, a question which your lordship will have to examine at the point in time, because unfortunately, my lord, as your lordships now see, once the ship has sailed, the only thing left really is security now, which security is to be utilized for a particular purpose. And that purpose, your lordships will ultimately decide, as my lord, Bombay High Court examines it in greater detail than our High Court has, that you will use it as security, not try the suit for deciding as to whether the Admiralty claim is payable or not. And ultimately, when the award is made and brought into this country for the purpose of enforcement, your lordship will examine as to whether it's enforceable and then use this money which is kept as security to pay off a claim which is made. That ultimately is how, my lord, the structure has been made insofar as this is concerned. Now, please see the division bench judgment, my lord, which in this, I'm just passing on this. In Alta Suba, I'm just passing on, my lord, the single judge of Justice Sriram's judgment, your lordship saw, that was taken up in appeal before the division bench. You don't have the copy? Oh, I'm so sorry. You don't have it. I'm sorry. It's 2019 SEC Online Bombay 1327. It's not there. I don't know if my other friend has given it. you have a copy?
But I have it.
Do you have an additional copy? Any chance?
I didn't send it.
But do you have an additional copy?
My soft copy.
You have a copy. But I'm sorry, may I pass on my copy, my lord?
Yes.
It's unfortunately, I think one or two markings are there. Lordship, may pardon me. Do we have all this over TV?
One second, let me check. Yes, here.
All right, Lordship may use this note. I think this is not marked. Lord, 2 or 3 paragraphs in this judgment. Can I request my lord to look at para 60? I'll read 4 or 5 paragraphs, note, and nothing more than that. Para 60, the full bench, they refer to the full bench judgment, does not advocate a suit for interim relief only. It holds that an action in rem is maintainable for recovery of a maritime claim and arrest of a vessel where parties have agreed to submit disputes to I'm sorry, your lordship has it? Arbitration. This is not a suit only for interim relief, but a substantive action for recovery of a maritime claim. It is only when the ship is arrested and the owner enters appearance and submits to jurisdiction that the court will not proceed with the suit in personam on merits, but refer the parties to arbitration. Thus, what in effect happens is that the suit is stayed, consistent with Section 45 of the Arbitration Conciliation Act. Retention of security is then a matter of discretion for the court in the event the suit is stayed. It may be borne in mind that interim relief is not a matter of right, but is always discretionary. However, the Admiralty Act provides for a right in rem to arrest the ship to obtain security for a maritime claim. This right is a substantive right and cannot be denied to the plaintiff merely because the underlying disputes have been and or are required to be submitted to arbitration unless there is an express bar, and there is none. Then please come along to para 66. The Admiralty Act 2017 is a special act. However, it is not a self-contained code unlike the Arbitration Conciliation Act 66. There are several other statutes which deal with arrest and detention of ships in maritime claims, notably Merchant Shipping Act, Indian Ports Act, Major Port Trusts Act. Observations in Balcoa with reference to the Arbitration Conciliation Act, being a self-contained code as held in first. Thus, it is not permissible to look outside the Arbitration Act in order to fill any lacunae. These do not apply to the Admiralty Act 2017, which is not a self-contained code. Admiralty Act only deals with what constitutes a maritime claim. Arrest of ships to secure maritime claims. Act does not provide for what is required to be done after a ship is arrested to secure a maritime claim and the owner enters appearance and submits to jurisdiction. The Act is silent on the procedure to be followed in the event disputes are to be referred to arbitration. Consequently, it is open to the court to look outside the Admiralty Act and adopt and apply general principles and broadly accepted international procedure to evolve a procedure which involves interplay between actions in rem and arbitration so as to advance the cause of justice and which is not prohibited by domestic law as was done in Golden Progress. This procedure can be applied without any difficulty or conflict once a ship is arrested in respect to a maritime claim under the Admiralty Act. If the Admiralty proceedings are stayed and security is retained in the suit pending final outcome of the suit, same is consistent with Section 44 of the Admiralty Act. Once there is an award which is not satisfied, then an application is filed in the court for filing the stay and to rely on the award as binding between the parties. Conditions specified in Section 48 are satisfied. Section 46 of the Arbitration Act permits the award to be relied upon in any legal proceedings in India, and all references to enforcement of a foreign award shall be construed as including references to relying on an award. If the objections to the award under 48 are rejected, award will be considered as binding on the parties as per Section 46, which permits the award to be relied upon in any legal proceedings in India. Suit is then decreed on the basis of the award for the sums awarded. Got that note at para 67?
Yes.
This is the final outcome of the suit. Security can then be made available to the plaintiff in execution of the decree. No statute, please see 68, no statute caters to every fact situation. The submission that what is not provided for is implicitly excluded is not correct. Admiralty Act is not a self-contained code, unlike the Arbitration Conciliation Act. It sets out the extent of the jurisdiction of the court, territorial and over ships, a list of maritime claims, and the power of the court to arrest a ship for the purpose of providing security in respect of a maritime claim. Admiralty Act does not refer to stay of admiralty proceedings once the ship is arrested and security provided. That comes in by virtue of Section 45 of the Arbitration Conciliation Act 1996. This does not mean that the suit is not maintainable or that there is an implied bar. The presence of an arbitration agreement does not oust the jurisdiction of civil court. Even if the suit is stayed, there is no bar to retention of security in the suit. Apex Court in several judgments supported such interpretative changes having regard to the ever-changing global scenario. In the case of Al-Kumar, Apex Court also observed, court has to approach modern problems with some amount of flexibility, as is now being faced in the modern business trend. Flexibility is a virtue of the law courts, as Roscoe Pound puts it. Pedantic approach to the law courts are no longer existing by reason of the global change of outlook in trade and commerce. Then 72, my lord.
Yes.
Submission that once there is an arbitration agreement, arbitration has been invoked, court has no jurisdiction to arrest a ship in exercise of the Admiralty jurisdiction has been specifically held to be incorrect by the English Court of Appeal in the Andrea.
Yes.
Thus, the purpose of the plaintiff invoking Admiralty jurisdiction cannot affect the existence of the jurisdiction. Thus, it cannot be said that the court has no jurisdiction to arrest a ship or to maintain an arrest, where the purpose of the plaintiff is simply to obtain security for an award in arbitration proceedings. The jurisdiction is simply there. The court has power to arrest. Then, my lord, one last paragraph which I want to point out is, my lord, para 122.
Yes.
We have carefully perused the order of the learned single judge, and we find that the learned judge in paragraph 52 has observed, plaintiff gave the vessel CM Arlen on a bareboat charter to Meds under a bareboat charter party. Thus, Meds was a demised charter of the plaintiff's vessel. This is the conclusion that the court drew. The plaintiff had various claims in respect of breach of this charter party. They are maritime claims under section 4. Learned judge then rightly refers subsection 5 of section 5, read with 5(1)(b) to hold, plaintiff is entitled to arrest a vessel which is either owned by or on demised charter to Meds when the arrest is effected. Learned judge says plaintiff has referred to Meds as owner of the defendant, vessel Altus Uber, and in support of this assertion, it relies upon the documents in so and so that shows Meds is the registered owner. IR classification documents, the classification society IRS confirms registered as Meds, and the former owner of the vessel Swordsfish. Thus, the documents on the website of Meds have been referred to by learned judge. Learned single judge says that there is a failure of Meds to disclose the alleged bareboat charter party under which it claims to be a demised charter. Therefore, the assertion cannot be accepted according to learned single judge. That is sufficient to prima facie demonstrate. Meds is the owner of the defendant vessel. Learned single judge is also referred to the denial of Meds that they are not owners but are demised charters. Learned single judge rightly says that this makes no difference to the arrest of the vessel. Learned single judge has also rightly made the distinction vessel and any other vessel. Learned single judge holds that assuming Meds to be the demised charter, it's still applying so and so, the defendant vessel is liable to be arrested for the purpose of providing security. Which is why, my lord, I said these are questions which require an answer, and on this question there may have to be trial. Please examine that question, and which is why, my lord, I made this application for an amendment.
I number 5. I number 5.
My application.
No, not I number 5, 4.
I number 4, my lord. I'm sorry,
I number 4 filed by him.
You lord.
That will order then.
Yes, my lord. On costs, then, Lord, what will, of course, I'm not saying costs, my lord, cannot be determined. It is cost of the proceeding, not damages, which they claim. Therefore, this has actually, I didn't get a judgment, but there's a clear judgment, Lord, that order 25 orders will have to be made. Your lordships can make that order, but the cost which will be fixed will be cost under the civil rules of practice, under the Karnataka civil.
Yes, as per the application, how you have assessed it?
Yes, my lords, I will point that out. But may I, my lords, answer this? I was to show that direct judgment on this.
No, because you're not going into that.
No,
we
my
are
lords.
deciding I number.
May I say this, my lords? Vacating is my main application. The alternative application is I4, and I must, my lords, point this.
In fact, court wants to decide it. The difficulty is there are some more matters listed at 2:30. All of them are waiting. That's specifically listed at 2:30. All the remaining matters.
My lords, I don't mind, my lords, if my lords accommodate me on Monday or whatever, but my lord, this in my respectful submission is absolutely critical. This judgment which is relied upon is in context of whether pendency of arbitration will, it is not deciding the issue of whether for a claim of a charterer can a vessel be arrested. My only request is, my lords, I will not exceed, my lords, I just have to show those two judgments.
But civil rules practice, there's a mechanism for calculation of costs.
80. Monday, there are several matters may not be possible.
Your lordship may indicate a day. I will make ourselves available. Now, this is, in my respectful submission, one of the most important issues because it's an issue of jurisdiction. If the jurisdictional test under section 5 is not met, my lord, then, my lords, there is no power to retain security. But that in fact is the argument on a prima facie. And my lord, here there is hardly any dispute. Here the fact of Here the fact of the matter is, my lords, they admit that the claim is against the charter. I will show direct judgments, my lords, on this, where the claim is against the charter.
How many? 21st. We'll have it at 10:30 on 21st.
At what time?
10:30.
Yes.
So that the remaining matters in the forenoon I'll complete.
Very well, very. Yes. But I don't know which.
Something interesting. Like
Yes, no, it is definitely interesting. Something new for all of us, especially for us. My learned friend, I'm sure, is doing it every day, but
Not
we
every
don't
day,
do
but
it every day.
Done some of them. We all learn in the process.
Yes. 21st at 10:30.
At 10:30, my
The
lords.
list.
10:30
Now,
list.
file it in the section in the registry.
We'll file it.
My lords, if we can only, if I mean, this is only a suggestion. If it meets with my lords, even my friend, we can come, my lords, with my lords, keep our written arguments ready.
That is.
And on the next occasion, after we come, as no sooner we conclude, my lords, we'll tender.
Because we are hearing on his vacate petition.
Vacate my amendment, Lord, because
No, that if the court is not going to allow his vacate petition,
no, there are two things.
even that day also will allow your, if required,
Yes.
will allow it.
Very well.
We'll hear that vacate petition, whatever contention that are raised, whatever argument that you are going to.
Of course,
put
no.
forth, written arguments
I'm
will
duty bound to answer everything.
No,
There's no
written
question.
arguments will.
We'll also keep
better on
one.
that day
I'll
you
try
would-
and keep a written
Yes.
submission. I'm great.
21st and 10:30. We are extremely okay.
At 10:30. And you remind me on that other matters, less matters will have. Paul?
Passed over matters in list number 2, serial number 2. Passed over matters, list number 2, serial number 2.
Yes.
Damage claim.
Yesterday's matter.
Please.
Please come. The claimant is before this court. Agreed with the award passed in MBC number 917 of 2006, dated 26 February 2011. The claim is made seeking an amount of rupees, how much?
Earlier it was dismissed, please, not later after remand for 2,34,000 has been awarded.
Sought for damages to the vehicle. The tribunal has awarded an amount of rupees 2,34,000 on account of damages caused to the Toyota Palace Maxi car. And also, the court has not awarded interest from 27/2/2008 to 29/1/2011. At the rate at 6% interest. While granting the compensation, while granting the damages, the court has observed that it is the case of the petitioner that due to the accident, his Qualis was completely scrapped and was taken to the Swagat Auto Works, Mangalore, and kept in the garage until today. The vehicle is in the same condition as caused in the accident. The surveyor is examined as PW4. PW4 had 14, PW14 had stated that on 17/6/2005, at the request made by the United India Insurance Company, he has inspected Toyota Palace Maxi Cab number KA 19A6552 and accordingly has issued report as per Exhibit P146. Exhibit P146 is a survey report given by PW14 surveyor And in the report, he has assessed and noted that the vehicle was completely scrapped and it is not, it requires, it is in need, it is not, it is in need of repair. Therefore, it was assessed and estimated as a total loss cost to the vehicle. As per the survey report exhibit P146, the insured depreciation value as per the policy of insurance is stated as 4 lakhs. The salvage value of the wreck along with RC book is assessed at rupees 1,65,000. Further, the surveyor had deducted excess clause of rupees 1,000. Accordingly, as per that, it is assessed and estimated that as the claimant has sustained total loss of rupees 2,34,000. And the court had granted the same. This matter, this appeal is filed by the claimant in the year 2012. On right on several reasons, adjournment was sought and the matter time and again adjourned. When this matter came up on the last occasion, that is on 15/4/2025, at the request of the counsel for the appellant, the matter was listed today as part third. In the, what to do? Your arguments to be recorded?
My lordship, sir told like on the 21st he required time.
No. And finally, time was granted and the matter was directed to be listed on 16/4/2025. Again today when the matter came up, then counsel for the appellant, then counsel representing the counsel for the appellant has sought for time. An appeal of 2012 cannot be kept pending. And this court is proceeding to decide with the same on the merits of the matter. Then counsel appearing for the respondent insurance company had submits that the court had rightly granted the compensation and there are no grounds to interfere with the same. Having heard the counsel for the respondent, there is the material on record. Earlier, the petition filed by the claimant was dismissed on 27/2/2008 on the ground that he has not produced any evidence to show that he is the owner of the Toyota Palace Maxi Cab. Later, an appeal is filed and in that additional evidence is produced before the court. Then the matter was remanded to the tribunal. And in the MFA, this court also perused the reasons stated by the court at para number 11 for arriving at a conclusion that the claimant is entitled for an amount of rupees 2,34,000. That is basing on the surveyor's report. No other document is placed by the claimant. And basing on the available evidence, court had rightly granted the compensation and there are no grounds to interfere. Dismissed. Next.
Then number 3, A.N. Krishnaswamy for appellant, Pundika Ishwara Bhatt.
They appear for the appellant.
What do you say?
Appear for the appellant
I remember.
in the second matter.
I am for the respondent in 3.1.
Yes.
In the 3, Krishnaswamy appears for appellant. He wants tomorrow, my lord.
It's adjourned for him. Why Krishnaswamy wants tomorrow? Yes.
My lord, he is on his legs, on his in the other court.
Oh, that is, he wanted adjournment last occasion. Yes. It is about 163A.
No, it is treated as petition filed under section 166, as could be seen from the finding. Kindly see the finding, my lord, on that.
No,
That is,
if the court had taken it as 1 under 166,
please.
or once you filed under 166, court had granted under 163A.
No, 160.
166. 166.
It treated as 166. Petition is filed.
In that case, negligence has to be proved.
Please, my lord, I have proved. It is very clear from the finding of the
On the
court.
last occasion, why is it adjourned? Court was discussing about some, the judgment or some legal question. At that point of time, you sought time. What is that?
My lord, what happened? He filed an application under 166. Then he got it converted into
No,
163A.
that is withdrawn with the permission. Then it was treated. Subsequently, what happened was a 207 of 2003 was the petition filed. As could be seen from the judgment, the finding. Kindly see.
Finding.
My lord, para number 9, reason, para number 9, my lord, where it is in the bottom portion, it is pertinent to note that your lordship got this para number 9, bottom portion, 3 or 4 lines, just above.
Yes.
Para number 9 of the judgment.
Yes.
The respondents have disputed about the, it is pertinent to note the petitions have filed earlier petition under section 163A of ME Act. In MEC number 207/3, the respondents have disputed because the income is more than 4,000. That is, therefore, the petition is, however, it is not maintainable. Sought permission and filed the fresh petition.
Read the judgment. This petition is filed. Judgment. This award starting.
Please.
For rupees 7,50,000 and subsequently got amended it claiming under section 163.
Oh,
of the
please,
Act.
please, my lord.
That is what I am saying. When your income is
More
above-
than if it is so, my petition is not maintainable. Certainly, the petition is. The income is more.
Not restricted. What is
No,
your
the
income is what-
finding, my submission is that the finding of the tribunal that it was treated as 166. For the finding of the tribunal, kindly see the finding, para number 9 onwards. Kindly see, for a moment, kindly see the findings of the tribunal.
Yes.
The petitions being the LR so and so have filed this petition.
Which para you are reading?
Para number para number 10 onwards, my lord.
Please read.
Better to para number 10 onwards. So it is proceeded to consider the present case on the hand. The claimants have claimed compensation under section 166 of ME Act. The negligence aspect on the part of the victim and the driver of the bus has to be considered. The documents referred are exhibit P12 and 1 to 12 to 14 as they are. Certified copies of FIR, PM report, spot measure, sketch and IME report pertaining to the said accident. PW1 and 2 have stated about the said bus and the manner of the accident. The respondent 2 to 4 have specifically stated that there was negligence on the part of the deceased Lakshman as he had ridden the bike overtaking the tempo which was proceeding ahead, and the accident was taken place and he had sustained injuries and he was shifted to the hospital for treatment, but during the treatment he succumbed to injuries. No doubt PW2 has spoken about the manner of the accident and witnessing the accident as he was proceeding in the bus seated on the back side of the seat of the driver in the bus, and noticed that the deceased on his said bike and had overtaken the tempo, and in the process, he dashed against the front extreme right side of the bus, and there was negligence on the part of the deceased. The documents referred by the respondent to during the course of evidence of the administration officer as RW1 are relevant documents. Those are exhibit R1 to R8, insurance policy certified copy of MEC 207/3 memo filed by the petitioner, so and so, so and so. Then, para number 11, the said documents, the said document is exhibit P11 issued by the Vice President Bangalore Refinery. That is the salary certificate. I will skip 2 or 3, 4 lines, my lord. The contesting respondents have taken specific defense that the deceased was earning monthly salary of rupees 7,000, so and so. Then on the bottom, and the reason higher income is deceased, it was the duly withdrawn with the due permission to file the present petition under section 166 of the Act. Exhibit R6 annexed with the salary slip of the deceased as breakup at rupees 7,397, and the net salary of the month of February 2003 at 5,329, so and so. Though there is variance, but the respondents have taken the support of these documents. The evocation of the deceased as skilled employee is not disputed seriously. The age of the deceased was 43 years, and he was having promotional career in future, and it cannot be discarded. Hence, at this juncture, in the interest of justice, it is considered the income of the deceased was 6,000 per month. Thus, the income would be more than 40,000 per month. The claimant shall not claim the compensation against the permission granted in the earlier petition, which was filed under section 163A, and for which it was withdrawn, and to file this petition under section 166 MV Act. Hence, the amendment against the said order amounting to claiming the compensation under both the provisions does not have any legal force, because the claimant did not get portions of present petition with the reference to other important aspects regarding the negligence on the part of the driver of the bus, stating that the bus driver was driving in a rash and negligent manner, coming from opposite direction and hit the bike of the deceased, and the said portion are intact. The amount to due the claim under both the provisions of the Act, which is prohibited under the settled law. Hence, the petition is considered to be filed under section 166 of the Act, not under section 163A of the Act. On going through the evidence of PW1, she has stated that she was not an eyewitness, and she has not gone through the charge sheet, but denied that the accident was taken place only on account of sole negligence on the part of her husband. She has firmly stated that the friends of her husband told her that the accident was taken place due to negligence of bus driver. She has denied that in the complaint. It was stated that the accident was taken place due to riding of her husband, and the suggestion that it was due to negligence on the part of the deceased. Thus, she has referred the negligence on the part of the bus driver. The police records reveal that it was taken place after he had overtaken the tempo proceeding ahead. PW2, the eyewitness has stated according that the accident was occurred after the process of overtaking the tempo. PW2 made it clear that it was visible that the deceased was overtaking the tempo, but it has not made it clear what was the distance from the said bus when he was overtaking the tempo, and visible from such distance when it was on record that the process of overtaking was completed. One cannot expect that the deceased had not taken some amount of care, because the said fact overtaking the process does inspire that there was an occasion for the bus driver to take reasonable care on the public road. It is not hitting of the vehicle of the deceased directly on the front middle portion of the bus, so as to consider it that the deceased was negligent and sole wrongdoer to cause the accident. But the fact that the real state of affairs
Charge sheet was filed against the deceased.
please, madam, please, filed. Charge sheet was filed against the deceased, and soon after the accident, he was taken to the hospital.
So then whose negligence is accident has happened?
My lord, merely because the charge sheet was filed against the
What is the
deceased
other
does not
evidence?
amount to that he was negligent. The reason is this: the accident, as could be seen from the sketch, the accident was taken place in the middle of the road, my lord. Therefore, it can't be, there is no negligence on the part of the bike rider alone. Equally, the bus driver responsible for that. Therefore, the reasoning given by the tribunal in the following para is just and proper. It does not call for interference. The relevant portion of exhibit P1 was extracted by the trial court, and wherein the sentence Balabadi Mumbagada Kone Anchige, that is the front portion of the bus, just the bike hit against the front portion of the bus, not to the middle portion of the bus.
Mahajar, spot Mahajar, these are all part of the police proceedings.
Please, ma'am, please. Even in the Mahajar,
Please come.
and please, my lord, in
Missing your appeal.
Lordship may have it tomorrow, my lord. Krishna it appears
Even if his
arguing
appeal
other
also,
matter.
his appeal has to be dismissed, then also Krishna Swami has to
ಅವರ
come.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಕಾಗುದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್.
Agreed with the order passed in NBC number, award passed in NBC number 313 of 2005, dated 13th July 2012. Both the insurance company as well as the claimants are before this court. Claimants appeal is MFA number
May take the leave of this one, my lord.
10954 of 2013, and the insurance company's appeal is MFA 65 of 2013. The claim petition was filed seeking compensation of an amount of rupees 7,50,000, and thereafter they got it amended, claiming under section 163A of the MB Act for the compensation of rupees 4,25,000 with interest and costs. Later, the court had considered the said case under section 166 of the Motor Vehicles Act and held that the accident has taken place because of the negligence of the deceased as well as the driver of the opposite vehicle, and fix the liability at 50% on both, the negligence at 50% on both of them. And when it comes to the compensation, court had granted an amount of rupees 4,05,500. In this case, the charge, the counsel appearing for the claimant submits that court had rightly considered and held that
Accident has taken place in the middle of the road.
the accident had taken place
In the middle of the
because of the negligence on the part of both the driver of the bus as well as the rider of the as well as the deceased. It is submitted that the contributory negligence that is fixed is high. It ought not to have been at 50%. Next, it is submitted that the compensation that is awarded is not just and reasonable. Next, parallel counsel appearing for the insurance companies submits that when the charge sheet itself is filed
against deceased, against deceased.
That's what I am going to dictate. Yes. The charge sheet is filed against the deceased. When it shows that because of his negligence, the accident has happened. In that case, without any basis, the court has held that there is contributory negligence on the part of the driver of the bus, which is contrary to the evidence on record. The court at one stage application under 166 is filed. Again, it is converted into 163A. Then again 161, and again the court considered it as under 166. It makes it clear that the converting this from 166 to 163A as a name, as the negligence is on the part of the driver, on the part of the deceased.
Yes,
They've come up with such an application, and the court without basis had granted the compensation. Next para. Having heard the counsels on either side for information on record, the claimant is relying on the Mahajar and the spot Mahajar
Mazar and sketch.
exhibit P12 and exhibit P13. The insurance company is relying on exhibit R2, and even these Mahajar and the sketch are also part of the police records. He has also filed the FIR in the complaint. Those documents are relied on by the counsel, which by the claimant, which shows that the deceased was at fault. When an application is filed under 166, the claimant has to prove the negligence of the opposite vehicle. The finding of the court that that there is the negligence on the part of the driver of the bus is without any basis, and by considering only part of the documents and without giving any finding on the charge sheet that is filed against the deceased, holding that he is responsible for the said accident. In the considered opinion of this court, the claimant had failed to discharge, they have failed to be discharged their burden, that the negligence is on the accident has happened because of the negligence on the part of the driver of the bus, but not on the deceased. And the material available on record points out at the negligence of the deceased, which was not properly appreciated by the tribunal in that view of the matter. This court finds no reasons to interfere this court finds that the order under the order impugned needs to be set aside. Accordingly, the order dated so and so is set aside, and the appeal filed by the insurance company is allowed, and the appeal filed by the claimant is dismissed, and the amount in deposit shall be transferred, and the insurance company is at liberty to withdraw. Yes.
Serial number 9. Nameed Ahmed. B. Pradeep.
Yes, Pradeep. Why it is?
I to pass on. Lord, in this case of injury, my lord, the claimed compensation for about 10 lakh. The compensation awarded, my lord, 5,32,080.
5 lakh?
32,080.
What is the disability as per the doctor?
Fracture of both the bones, my lord. Both femurs, my lord.
No, disability according to him.
Working as a teacher, my lord. He is continuing the same profession. There are some loss of pay that has been granted. My lord, other aids, my lord, pain and suffering and amenities, my lordship may interfere. The two aids, my lord, para 12.
According to the doctor, what is the disability?
30% to the limb, 20% to the whole body.
We'll take it 10%. It may be, no, but it will have an impact on anybody's life. It's not that
government employee, government high school teacher. PW4 who has been examined before the tribunal has categorically stated that she has been continuing the same profession.
Where is the chart?
Para 11 of the judgment. What is the loss of payment? 2,30,000 that has been granted.
1 minute. Para 11.
Para 11. Issue number 4. PW4
no.
asthma.
No table.
No table. Table in the synopsis not there.
Maybe in the synopsis it must be there.
So synopsis also not there. The claimants are not put it. Para 12 million pain and suffering. 50,000.
Pain and suffering how much?
50,000 has granted.
Injuries are 2.
2 fractures.
2 previous injuries.
Previous.
How many days he was in hospital?
26 days.
How much is granted?
10,000 each, 20,000 has been awarded. Attendance charges and nourishment. 25,000 loss of amenities.
No. So you said 28 days.
26 days.
26,000. Then loss of amenities, how much is granted?
25,000.
35,000.
My lord, later period is concerned, my lord.
Medicines, medical expenses.
Medical expenses, my lord, 2,07,000.
2 lakh? 7,000.
7,000.
Loss of income during the later
Later
period
2,30,080
as per the evidence.
as per the salary, my lord. A salary, my lord, 30,470.
How much? How much? 2
30,
lakh
30, 2,30,080.
0
80.
2. Any future operation?
Any future operation not discussed, my lord. Lordship could have granted another 20,000 or 30,000.
How much is coming?
Pain and suffering,
Legal expenses.
10,000.
It comes to some wrong calculations. Something is wrong calculation is
My lord, 5,32,080. There, my lord, in one para, they have mentioned 5,82,080. Actual calculation, last order in the order portion, it is there.
how much this is
5,32,000.
coming? This calculation is coming
This calculation. Pain and suffering 50,000.
60.
60,000. Please. Yes. Medical expenses as it is. Loss of amenities 35,000. Loss of amenities.
Loss of amenities 35,000.
Food nourishment attendance charges.
26,000.
26,000. It's 5,88,082. Every time it is
Correct.
the calculation is coming 15 lakhs.
Correct. 5,82,000.
Agreed. Against the
5,32,080.
5,32,000
080.
08.
0.
What is the name of the advocate who filed the no objection? His name is reflected.
Javed.
No.
Javed.
Javed.
Morning, your colleague has submitted. Javed.
Take his name. It's there in the list.
It is Naveed Ahmad Aureta.
Naveed Ahmad, it is shown.
This on record council mod it is.
Then write the name and give. Agreed with the order passed. And this is MBC number?
List number 2, my lord.
No, MBC number.
MEC
There are two
number
MBC.
608.
Huh?
608, my lord.
Agreed with the orders passed in MBC number 608 of 2015 dated 13th September 2017. The claimant is before this court seeking enhancement of the compensation. It's a case of the claimant that he had sustained grievous injuries and he was in hospital. And as per the evidence of the doctor, he had sustained disability and the compensation that is awarded by the tribunal is not a just and reasonable compensation. Next, President Counsel appearing for the insurance company submits that the court had granted reasonable compensation. No interference is called for. Next, having heard so and so, considering the two grievous injuries sustained by the claimant, this court is granting an amount of rupees 60,000. Coming to the food nourishment, as he was there in the hospital for 26 days, 26,000 is awarded. According to the doctor, he had sustained 10% disability or 20%?
20%, my lord. 30% to the limb, my
30%
lord.
to the
20% to the
limb
whole
and
body.
20% to the whole body towards loss of ability. This code is granting 35,000 towards medical expenses and loss of income during the laid-up period. Court had rightly granted the compensation as the disability has no impact on him and he is working and no interference is called for. Towards future operation, no amount is granted. This court is granting an amount of rupees 20,000. In the light of the law laid down in so and so towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,88,082. Appeal is partly allowed by enhancing from 5,320,802 to 5,88,082. Yes, next.
Cell number 15, Chandrasekhar Patil.
Please. The memo minute I have mentioned the advocate to whom I have served.
Put in the name of so and so. Action. It is submitted that as per the order passed for this court, he has served the hand summons of the counsel appearing for the respondent and filed a memo to that effect. The registry is directed to put in the name of Mr. Hetchen.
Himant Raj.
Look at it. Yes. This is matter on Thursday.
Interim order may kindly be extended.
Look at it. Yes, next.
Please.
Cell number 32. Cell number 32.
Petitioner, my lord. I'm filing rejoinder to the statement of objection. Rejoinder to the statement of objection. We filed our objection, my lord. It may kindly be put up, my lord.
Morning
Office may
it
be
was
done.
there.
Yes, my
Morning
lord.
it was there. I have rejected the request for adjournment. That's why it's coming up again. Why are you asking for adjournment?
We seek for a pass over, my lord, but the objection is not put up, my lord. That may kindly be put up.
What is your objection?
On the transfer application, my lord.
When did you file your objection?
Yesterday, my lord.
List is marked tomorrow.
Yes, ma'am.
Along with the objections filed by the respondent and the counsel for the petition. The petition or
Petitioner.
petition has filed a rejoinder to the same. Yes.
Interim order may be extended. Interim order may be extended.
Interim order only granted is extended. Next.
Cell number 50. 52. Cell number 52.
No, stop this list. Go to the 230 list. All these matters will continue. And in this, all 53, not 52, 52 is 2016. It will remain to be there. 53 to 59. All give the dates after vacation.
My lord, 54, my lord, kindly.
Let's settle.
54 to be referred to Lok Adalat. It is submitted to the matter may be referred to the Lok Adalat mutual order. Yes.
My lord, deal number 59 may require short indulgence because the pleadings are complete. The deal number 59, the matter requires only short indulgence of my lord.
Problem is Lok Adalat matters are there. That's a whole difficulty. We'll give it immediately after vacation. Let's a matter on June 16th. Remaining matters, give the dates.
Cell number 52, my lord. 52.
After
53,
vacation,
ready
the date
the
will be
way.
given.
Well, it can be disposed of, my lord. Quantum. 53. Only quantum. There are two
50?
insurance company. 50-50 is only quantum.
Only
Only quantum.
53.
Please.
Give that 53. Yes,
Like the fracture of humerus of middle 1/3.
please come to the table.
Para.
In page number,
How many are, what are the injuries?
Fracture of humerus middle 1/3 left with radius nerve palsy.
radial nerve palsy.
2 grievous injuries,
Only one.
40,000.
My lord,
It is-
but it is, kindly see that in page
Court has
number,
granted 30,000 of.
in page number 17, it is a fracture of left humerus with wrist drop. That is nerve palsy, my lord.
Nerve palsy,
For
correct.
that
Radial
reason,
nerve
minimum
palsy.
50,000 has to be awarded,
50. Yes, next.
my lord.
Laid up
Under
period,
loss
my
of
lord,
income in the laid up period,
Cheer,
2013,
2013,
2000.
13,
What is the amount?
8,000.
8,000 into 3. Then medical bills as it is.
Loss of future earning.
1 minute.
ಎರಡು ಸೇರಿಸಿ ಕೊಟ್ಟಿದ್ದಾರೆ
ಇಲ್ಲ
ಎರಡು ಸೇರಿಸಿ
ಇಲ್ಲ ಇಲ್ಲ ಇದು ಬೇರೆ ಇದು ಬೇರೆ.
What is the disability according to the doctor?
37%, my lord.
8% is taken, 13% doctor says.
Can be
Whole
taken.
body 13%, my lord.
So, loss of future income, 8,000,
Into 12 into 11 into 13.
12 into, what is the multiplier?
11.
11.
To 13.
One lakh 37,280.
1,37,000.
280.
280.
And also
Then,
loss of
how many
amenities,
days
my
was
lord.
in hospital?
15,000 is granted,
How many days he was in hospital?
2 days.
3 days he was. She
Then
was
that is reasonably granted.
another 15,000, my lord.
But
Because
it can't be mixed. The loss of
How can it
amenities,
be?
conveyance, food and everything.
Ah.
So, for conveyance,
2 days.
nourishment and all will grant 5,000. And for loss of amenities for disability, 30,000.
Please. Future medical expenses.
doctor stated that 55,000 required
What is required?
for removal of implants, my lord.
Another 5,000.
Due to nerve palsy, my lord.
Huh?
Due to nerve palsy,
ಚಿನ್ನದ್ದು ಎರಡು
the
ದಿನ
hand will be
ಅಷ್ಟೇ.
not stand properly.
5,000 is granted.
Another 5,000.
In
Telescope.
regarding amenities, my lord.
Separate ಕೊಟ್ಟಿದ್ದಾರೆ sir.
Amenities is granted.
Kindly be 30,000, my lord. Regarding
30,000 is granted amenities.
please, man.
After granting again you ask, we will reduce it.
No.
How much was taken by the court? The income?
Blood score 6,000.
It's coming to 4 lakh
Correct.
18,490 against 2 lakh 84,000
130.
134. Please come. The present appeal is filed with the claimant seeking enhancement agreed with the award passed in MVC number 2854 of 2013 dated 30th August 2016. The claim petition is filed seeking compensation of an amount of rupees 8 lakhs and the tribunal has granted the compensation as per the table given below. Learned counsel appearing for the claimant submits that for the injury sustained by the claimant in the accident under the head of pain and suffering, the amount that is granted is on the lower side. It is submitted that the court had considered the income only at 6,000, which is on the lower side. When the doctor had opined that the disability to the whole body is
13%.
37.
13%.
Whole body is 13, 1-3.
That's
Yes, ma'am. 13.
13%, but the court had taken 8%, which is on the lower side. It is submitted for the loss of amenities and for under the other heads also. The compensation that is awarded is not reasonable. Same contentions in respect of insurance company that there is a just and reasonable compensation. Having heard so and so, the claimant had sustained one where are the injuries you find?
17 in page.
Huh?
Page number 17 in the judgment, my lord. First line.
Fracture of humerus
The-
middle 1/3 lap with a radial nerve palsy.
No, no, where is that? I'm not able to see.
In page number 17, inside page.
24 Miller, page number.
20?
Allah, 17.
Only one fracture of left humerus.
Under which caption it is dealt with? Medical expenses, loss of income to fracture.
Issue number 1, pain and suffering.
He had a fracture of the left humerus with wrist drop, radial nerve palsy. Considering the same, this court is granting an amount of rupees 50,000. Coming to the income, this accident had taken place in the year 2013.
13.
And this court is taking 8,000. And for the loss of income during the later period, this court is granting 24,000. Towards the medical bills, court had rightly granted the compensation and no interference is called for. Coming to the loss of future income, when the doctor's evidence is that he had sustained 13% disability to the whole body, court had taken 8%. Hence, this court is taking 13%. 8,000 into 12 into 11 into 13 by 100 is 1,37,280. He was in hospital for 2 days, but under the caption of conveyance, attendant and nourishment, this court is granting 5,000. For the loss of amenities, considering the disability, this court is granting 30,000. Towards future medical expenses, 20,000. In the light of the law laid down is also legal expenses. So it's altogether an amount of rupees 4,12,490. Appeal is partly allowed, enhancing from 2,86,134 to 4,12,490.
Interest 8%.
Interest enhanced amount 6%.
First and second.
Without saying it will go.
Please, first and second respondent equally respond. Contributing.
There's no, he is on only enhancement.
Please.
Whatever the remaining things will
Please.
continue.
Much obliged.
Next.
Lord, in a list 3, serial number 14, we've settled the matter, my Lord.
We don't settle the matter.
Pradeep.
List 3.
Serial number 14. Another global compensation, 60,000 rupees.
When you will file the joint memo?
In the Adal.
When? Will fix a date or anything is required or?
No, they will prepare, my lord. We will.
They will, yes.
Serial number 9 also it is set.
1 minute.
24th.
By 24. Yes. So what we'll do is, we'll fix a date.
Please.
Fix a date before the Lok Adalat.
That would be better.
We'll sit and, that will do. What he's saying is, for that I'll sit on after 4:30 and we'll record it.
Please.
We'll fix a date. Which you said?
Serial number 14, Lord.
Serial number 14.
In third list.
It is submitted by the council appearing for both the council that insurance company is has agreed for the agreed to pay an amount of rupees
60,000.
global compensation.
Global compensation.
60,000 global compensation, and they'll file a joint memo on. We'll say.
24 they want.
Second. 22nd.
Please, any day, my lord.
24.
It's not list, it will come in the evening. 22nd. 22nd. Then next month.
Serial number 15.
15.
We have agreed for global 50,000 rupees minutes warrant.
Same, in this global compensation of 50,000, same day, joint memo. Next. Somebody else. Serial number? Serial, 1 minute. Serial number 9?
50,000.
50,000. 50 or
50.
50 global compensation, same date for the joint memo. Any other matters?
Serial number 4, there are no chances of settlement.
4.
It may be retained in the court. It may be referred back to court.
It is submitted that. Then we'll order this. 4, it is submitted, there is no scope for settlement. The needful shall be done within a week.
Serial number 6.
4 you are saying?
4 Miller.
Needful shall be done within a week, or else the appeal shall stand dismissed against R1 and R4.
Serial number 6. One more matter. Serial number 17. There is company appeal also.
Serial number 17.
Company appeal 3906 of 21.
Then if the company appeal is there, you cannot settle it. It is submitted that there is no chances of settlement. 17, list is matter in the usual course for final hearing.
Serial number 6 also, my lord.
Serial number 6, what?
It is not settled.
It won't settle. This also list is submitted that no scope for settlement listed in the usual course. Yes.
Serial number 3, list number 3.
Ah.
Records is required in this case.
Memo is filed seeking dispensation of notice. Same memo is taken on record and dispensed with. Admit, call for the TCR. Yes.
Serial number 12.
Serial number?
12 mail. Insurance company is not agreed with the settlement post.
Company?
Not able to, not give, enhance the amount, my lord.
Not agreed to the amount what they are offered.
My lord, compromise is not possible. It may be posted in the usual course.
What is that he's asking?
My lord.
Insurance company's
3 lakhs
negotiation is
submitted,
not
settled.
not settled, my lord.
It's submitted that the matter, what they're not, the matter cannot be settled before the Lok Adalat and they want the matter to be heard on the bench. This matter in the usual course for final hearing.
13 also, my lord. 13 also.
13 also same.
And 16 also. About 63 lakhs is granted. We have paid that amount.
16 also same order.
Serial number 2, my lordship. It is pay and recovery, my lordship.
Which one?
Serial number 2, my lordship.
Take that. 2 is filed by?
Pay and recovery, my lordship.
Maybe they're asking for enhancement also.
Yes, my lordship. The small enhancement is there.
We'll do that then.
The order is required.
No, that's what we'll do.
Yes.
Where is the council, Mr. Manjunath?
They are not happy. That's why, my lord.
Tomorrow we'll have it.
Yes, my lord. Yes, my lord.
2 tomorrow.
Yes, my lord.
18 and 19 may not maybe refer back
To the court. 18 and?
19 may not.
18 and 19 submits that there is no scope for settlement. List the matters in usual course.
My lord, same in serial number 21 and 22, my lords. It needs detailed hearing, my lords.
21.
21 and 22.
21, it's submitted that there is no scope for settlement. This is a matter for hearing.
22 also, my lords. 22 also, my lords.
Yes, 22 also. Yes.
Please.
Serial number 8.
Serial number 1.
8.
8.
It's settleable case only, my lord. I will approach that council who has not come today. And let Monday or Tuesday, any date.
Yes, we'll have it on Tuesday.
Please.
8. R1 for first time. Liability is not in dispute.
We're not disputing the award.
How much the amount is coming to?
66,000 plus interest.
This also tomorrow. Let's just matter tomorrow. You have calculated, we'll decide it tomorrow if he's not coming. Because anyway, it is not listed as Lok Adalat. So either ways we can do it.
Cell number 5, Shankraj K. SV Hector Mulkan.
A memo is filed seeking dispensation of notice to R1. Dispensed with. And IA number 1 of 21 is filed to condone the delay of 479 days. Condone on condition. Admit was for final hearing. TCR.
Cell number 7. Number 7, Vivekananda.
Appearing for
Reddy.
appellant, my lord. It's a short matter, my lord. I'm
Ashok L.
seeking-
Patil.
Yeah, agreed for 75. I convinced them. 75,000 global over and above.
It is same 75,000 memo on the day. Then 10.
Cell number 9 and
9 is over. 10.
10, Nagraj Egde.
What about 10?
Nagraj Egde, Rakesh Kini, correspondent.
Yes. What happened to 10? 10 doesn't belong to your company?
10 my lords, we have, company also has filed an appeal.
Filed appeal. It is submitted that there is no scope for settlement in the Lok Adalat. No, there is no scope for settlement. list this matter in the usual course. IA number 1/21 is filed to condone the delay of 14 days. Condone, admit, force of final hearing. Next 11.
Cell number 11, P. Mahesha. Yes, Sridhar.
There is a scope for enhancement, with no interest, it may be allowed. Condone. Delay may be.
No, delay will be condoned. IA number 1/20 is filed to condone the delay, same on condition. Next, what is the scope of settlement? Tomorrow, if it is, it can be settled tomorrow. Yes, next.
Cell number
20.
Cell number 23.
20.
20. Cell number 20. Nagaraj Hegde.
I am appearing for respondent insurance company.
Which one?
I am
20.
20. I am appearing for insurance company.
Can it be settled
It be settled, madam, but they are not.
tomorrow?
Cell number 20.
No, last time you said that, call that officer.
Sir,
No, last time you said that you'll give some cases where you people have sorted out about the, the feasibility of settlement.
Yes, my lords. In this, we will provide the list. We have not brought the list now, but in this list, around 7 matters have been agreed upon. So that
No,
is-
no, further, some more matters.
Okay,
7
okay.
matters are not sufficient.
Okay, my lords. I'll just
Yes.
working on it.
23.
Tomorrow, which company? Sriram General Insurance. She was she was telling that all the from the regional office also,
Yes, ma'am.
all approving. How many matters are going to be listed?
I think 108 we have given.
How many?
108.
108 all Sriram General Insurance. Huh? Hmm. But try to see that complete, except deleting that divisional bench matters, all matters are listed because your law officer appears to be
From the
very,
head office they are coming.
no, even the law officer appears to be enthusiastic. So she'll be doing some work. Delete it and let all the matters be posted. And even wherever you find, apart from what they give, wherever you find Sriram General Insurance, you add to this list. Tomorrow. Tomorrow, what are the matters? How many matters are coming? No, date given matters only list. But then let it be no. 7 matters and these matters, what do you say? It will, assurance is you should occupy the whole day.
Definitely,
If you
ma'am.
can 1 or 10 matters, we will post. So that our other matters I'll not add.
Please, my lord.
Tomorrow, date given matters are 7. What I was telling her is 7 matters and all your matters.
In all the cases, my lord, in wherever the quantum,
It's okay, then still fine. So don't mention Lok Adalat or anything. Just simple, like any other list. So what we'll do is tomorrow we'll have less matters and all these matters. So now today after this, just find out what are the other matters of Sriram General Insurance. Because their approving authorities are also coming, we can do some good work. CP, it doesn't take much time. I can complete the list within 45 minutes. Not so too many. If date is given or a memo is given, I mean slip is given, that only you list. So all done.
Number 23.
22, 23 post before the court.
Post before the court.
Post before the
It is submitted. There is no scope for settlement. 22 and 23. List this matter in the usual courts. You please give your matters. If you have tomorrow, because the less matters are there. If you can come, we can have it tomorrow or some other day you want.
Yes, next week.
Want
my lords,
something.
sometime we.
And in the meantime, try to list, sort out some more matters.
Yes, yes.
So that we can have, like how the Sriram General Insurance are having huge number.
Yes.
And what we did the other day is, wherever we have calculated, when it is not agreeable to the parties, next day disposed of all the matters. The day before yesterday, I think we have done it. About 23 or 25 matters were disposed of. So that also, like your time will not be wasted. Because you are in the, that's what is your problem, because you're coming to the court, nothing is happening, and again your people are going back. It won't. What we do is tomorrow, every matter we will call. If both of you say settlement, or we will calculate, we'll say settlement. If you agree, let your whatever officers are there, we calculate and we tell, they say agreeable, joint memo, not agreeable tomorrow for, so that no waste of time. What are you saying? Then give him no. Give him no. That's better.
Right. Yesterday. Waste
ಎಷ್ಟು ಒಂದಂಟು ನಾಳೆನಾ? ಅಯ್ಯೋ ಒಂದಂಟು ನಾವೇ ಬರ್ಕೊಳ್ಳೋಣ ನೀರು, ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ಒಂದ್ ನಿಮಿಷ ಇದು ಅಯ್ಯೇ ಅಲೋ ಮಾಡಿರೋದು ಕೊಟ್ಬಿಟ್ಟು 11 ಅಯ್ಯೇ ಅಲೋ ಆಗಿದೆ, ಆರ್ಡರ್ ಶೀಟ್ ಮಾಡ್ಬೇಕು ಅವರು.
ಅದು ನಾವೇ ಬರೀಬೋದು
20 ಎಲ್ಲ ನಾವೇ ಬರ್ಕೊಳ್ಳೋಣ. ಯಾವ್ಯಾವ್ದು ತೆಗ್ಸಿದ್ ನೀನ್ ಇವಾಗ? 2 1 2 11 20 1 2 11 ಅವ್ಳಿಗೋಯ್ತು. ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಆದ್ಮೇಲೆ ಇನ್ನ ಯಾವ್ದು ಇಲ್ವಾ?
75,000 ಗ್ಲೋಬಲ್ ಲಿಸ್ಟ್ ಅಂದ್ರೆ 22 ಬರೋದು ಕಾಮನ್ ಆಗಿ ಒಂದು ಹೇಳಿದ್ರು ನೋಡಿ, ಅದು ಬರೀಬೇಕು. ಆಮೇಲೆ 8 to 22 4 ಗೆ
ಅಷ್ಟೇ ಬಿಡು ನಾಳೆ. ಆಮೇಲೆ ಒಂದು ಈಗ ರಿಪೀಟ್ ಹೇಳ್ಬೇಕು.
ಅದೇ 9 ಬಂದು ಮತ್ತೆ ಗ್ಲೋಬಲ್ 50 ಗೆ 22 4 ಬ್ಯಾಂಕ್
ಸದಾ ಇದು ಬರ್ಕೊಂಡು
10 ಅಯ್ಯೋ ಅಲೋ ಮಾಡಿ ಯೂಸರ್ ಕೊಟ್ಟು ಅಡ್ಮಿಟ್
ಡೇಟ್ ಎನ್ ಯಾವುದು ಅಷ್ಟೇ ಅಲ್ವಾ ಬರ್ಕೋಬೋದಲ್ವಾ? ಅದೊಂದಾ?
ಇದೊಂದು ಅಯ್ಯೋ ಅಲೋ ಅಂತ ನಿಜ ಅಯ್ಯೋ ಅಲೋ ಆಗಿರವು, ಅದು ಹೋಗ್ಲೇಬೇಕು ತಾನೆ.
ಅದು ಅಯ್ಯೇ ಅಲೋ ಆಗಿದೆ, ಹೋಗ್ಬೇಕು ಊಟ ಮಾಡಕ್ಕೆ ಅವ್ರಿಗೆ ಅಡ್ಮಿಷನ್ ಬರುತ್ತೆ ಅಷ್ಟೇ. ಡಿಲೇ ಮಾಡೋರು ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಡೇ ಅಡ್ಮಿಷನ್.
ಆಯ್ತು,
ನಾವೇ ಕೊಟ್ಬಿಡೋದು, ಇವ್ರು ಬರ್ಕೊಂಡು ಸೈನ್ ಹಾಕ್ಸ್ಕೊಡ್ತೀವಿ.
ಒಬ್ಬನ್ ಪುಟಕ್ ಮಾಡ್ತಾರಾ?
ಒಂದ್ ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನಿಮ್ ಚೇಂಬರ್ ಅವರು. ನಾನು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ನ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಮೇಡಮ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕೂತ್ಕೊಂಡಾದ್ಮೇಲೆ ಫೈಲ್ ಕಳ್ಸಿದ್ರೆ ನಾನು ಸೈನ್ ತಗೊಳಕ್ ಆಗುತ್ತಾ ಮೇಡಮ್? ಹೇಳಿ ನೀವೇ.
11 ಆಯ್ತಾ?